University Commonwealth Law School Emergency Medical Services Law and Symposium. I am Dean Michael Hussey. I'm here at Widener Law Commonwealth. It's my pleasure to welcome you to campus. We're delighted that we're in a situation of being back on to be able to do CLEs on campus, and we're delighted that we have a little over 50 people joining us. As I was driving in today, the radio was playing the Beatles' Get Back. And although the lyrics really don't fit with what we're doing here, it did remind me of Doug and his fondness for the Beatles and his trip to Liverpool many years ago, as well as getting back on campus and getting back to doing the things that we were able to do pre-pandemic. So I'd like to thank all of those involved in putting this together today. I'd like to thank Corinna Wilson, Paula Hyder, Molly Ackery, Joy Boudreau, and Brian Fernbaugh, as well as Doug Wolfberg and Paige Wolfberg and Wirth for putting this together for us today. It's just wonderful to have all of you on campus to continue the discussion and so many important legal issues and policy issues related to EMS services in our communities and in the Commonwealth. So thank you for joining us today. It's a pleasure to have all of you here, and I'm looking forward to a really good morning discussing these topics. Good.
Well, thank you, Dean Hussey, and good morning. I'm Doug Wolfberg. I'm a 1996 graduate of Widener Commonwealth Law School, and it's really a pleasure to be back on campus and to have this program in person. This is, as Dean Hussey said, the third symposium. Last year's was virtual, and the ones before that were in person. The one before that was in person. So we're really delighted to be back in person. I really want to first thank Christian Johnson, Professor Johnson, who has been a instrumental person in both conceiving and supporting this program. So thank you, Professor. And of course, I'd like to also thank Dean Hussey for his steadfast support of the both first responder and military communities with programming at Widener. I really do say this with only a little bit of partisanship, being a Widener graduate. And that is that the commitment of this university and this school, the law school, to first responders and the military is really unequaled, I think, in universities, certainly in this area. Yesterday, I was on the main campus, and we had a very nice ceremony dedicating the new university ROTC Center in honor of our former Board of Trustees chair, General John Tillelli, who was a 1963 graduate of Widener, back when it was called Pennsylvania Military College. I don't know how many folks know that Widener originally began life for most of its 200 years as PMC. And so that dedication to the military and to first responders is really unequaled. So for anyone who is considering law school, and I say this as also a graduate with that background in EMS, as a former provider myself, that both the education and the commitment here to those communities is really outstanding. So I do want to thank the school for that. I want to thank Corinna Wilson as well. When Professor Johnson asked if we wanted to do this symposium again, I said yes, but not without Corinna. So we are delighted that Corinna has once again been able to assist us in putting this together. I do also want to thank all of my colleagues here from Paige, Wolfberg, and Wirth, many of whom are graduates of this institution as well, for their support, both as faculty and attendees here today, supporting this program. And on behalf of my partners, Steve Wirth, Dan Pedersen, and Ryan Stark, also here is Matt Konya, Christy Malott, Ken Brody, and did I miss anybody from PWW? No. But we were pleased to provide a grant to help support this program as well. Because we do strongly believe in giving back, particularly after all the opportunities that have been given to us. So with that, we do welcome everybody here to campus. It is, as I said, great to be back on campus. And we welcome those of you watching the live stream and the PCN telecast. So today we have basically a series of panel discussions with really a breadth of topics. And the first one of those that we're going to get started with. And I would like to ask Ken Brody, Ryan Stark, and Matt Konya to come up and take seats as the panelists here. And the first topic that we are going to talk about is beyond the Good Samaritan, the evolution of EMS provider qualified immunity. And as our panelists are taking their place here, one of the things that spurred this topic is really, I think, we are and will be seeing more conduct of EMS providers kind of under a big microscope. And this was something, not to say we're Nostradamus or anything, but we kind of predicted because, you know, if you look at some of the cases on police misconduct, which Steve and I will be talking about a little bit later in the context of the Elijah McClain case, you know, the focus nationally has been on the conduct of law enforcement. But if you play those tapes, many of which of these incidents have been recorded, if you play those forward, oftentimes you see substandard conduct or questionable conduct by the EMS providers who come, who are called to those scenes. So the question of EMS provider immunity, this focus will be primarily in the civil context, but both civil and criminal liability issues are becoming part of the national conversation in EMS. So we thought that this topic would be timely to really take a look at both how Good Samaritan immunity has evolved and where that might go. And it's important to know that history to have a sense of where it might go, particularly as these issues become more prominent in the public discourse. So with that, I'm going to get our panelists going. Which of you is got the short straw and is going first? Is that you, Ken?
Yeah, I think so.
All right, the podium is yours, sir.
So I guess one of the questions is, where did this whole concept of the Good Samaritan start? And I think you have to go back to biblical times and the parable of the Good Samaritan in the New Testament. And that parable goes like this, is that a man was walking down from Jerusalem to Jericho, and on his way, he's accosted by robbers who rob him, who beat him, who strip him naked, and leave him half dead on the side of the road. And after that, another man comes by, sees this naked and beaten man, but decides he doesn't want to get involved. So he keeps on walking on the other side of the road. And the second man comes by, and he also decides that he doesn't want to get involved and continues walking by. Then finally, a man from an area called Samaria, he comes by, and he's coming by with his donkey. He comes by and he sees this beaten, half naked man, or naked man, half beaten on the side of the road, and takes pity on him. And without any obligation to do so, he tends to that man's wounds. And then he loads him on his donkey, takes him to an inn, and continues to provide care for him. So that's where the label Good Samaritan arrives from, this good man from Samaria providing these good deeds. And that concept, that label has continued throughout the ages for an individual who comes upon someone who is seriously injured or ill, unable to help themselves, and then without any responsibility to do so, takes care of that individual. So that's how, at least my understanding is that's where the label Good Samaritan arises from.
And Ken, I'm sorry, you said that was New Testament?
Yes.
That's pretty good for a member of the tribe to quote the New Testament that way.
Well, again, I wasn't around back then. but
Oh, okay.
That's
I was
my
going to ask that as a
understanding.
firsthand account.
That's my understanding. And I think the parable was actually taught by Jesus Christ as a learning exercise. So, okay, so I guess another question is, well, how did the Good Samaritan civil immunity or immunity from civil liability come to the United States? And actually, it came through the common law. The common law was originally from England, and that was in the Middle Ages. A king of England at that time established various king's courts. And the judges in those courts, well, they didn't have any case law or any statutes to review when they made decisions. So they would make decisions based upon custom and what they thought was fair and reasonable. And a judge would make a decision using that criteria, and then other judges of the king's courts would make similar decisions, using a similar criteria. And that became known as the common law because it was common to all the king's courts carrying out the king's justice. And then what happened is that when the colonists, English colonists came to the United States, to the colonies, they brought with them the common law. And today that really has been set forth in treatises published by the American Law Institute, which is called Restatement of Law. And the Good Samaritan principles that came from the common law are published in the Good Samaritan, are published in the Restatement of Torts. And they have been accepted by the courts in Pennsylvania. You don't have to accept them. Courts in different states don't have to accept them, but the Good Samaritan, the common law Good Samaritan doctrine has been accepted in Pennsylvania. Now, there was a Supreme Court case actually that dealt with the common law Good Samaritan doctrine, and this was back in 1955. And that doctrine was basically this: someone without any responsibility to do so takes charge of an individual who is helpless and cannot take care of themselves. That person who takes charge of that individual will be liable for personal injury to that individual if, in taking charge, they don't exercise reasonable care in securing that person's safety. Or even after they do that, they discontinue the care that they're providing, leaving that individual in worse condition than they were when they originally were taking charge of. And in this particular case, a case of Caravas v. Pullis, the facts there were an elderly man went to a bar, tried to sit down in a bar stool. He fell down, and a bartender heard him fall, then turned around, saw that he was on the ground, came over to him, helped him stand up, helped him walk over to a chair and sit down in that chair. And the man then asked that a waitress call his daughter to pick him up. And the waitress called the daughter, and later the man's son-in-law came, walked him to his truck, and then took him to his own home until the next morning when he took him to the hospital. And at the hospital, it was determined that this man had a fractured hip. So the man, he decided he was going to sue the bar. He was going to sue the bar owners. So he sued the bar owners. And again, the case was determined under the Good Samaritan common law provision in the Restatement of Torts. He claimed that, well, he suffered additional injury after his fall by the bartender helping him up, walking him to the chair and sitting him down in that chair. Also contended that the bar owners were liable because they did not take him to a hospital that evening, that they had taken charge of him and discontinued the care, resulting in further injury to that individual. So the Supreme Court, this case actually went up to the Supreme Court. A jury had found in favor of the bar owners, and the Supreme Court decided that, well, this bartender, there wouldn't be any liability to the bar owners for what the conduct of the bartender, because the bartender didn't do anything that a reasonable, prudent man wouldn't have done under the circumstances. And with regard to the claim that the individual wasn't taken to a hospital, well, the Supreme Court didn't address whether he should or shouldn't have been taken to the hospital, but concluded that the evidence at trial didn't demonstrate that this person suffered any additional damage than the damage that had been encountered when the individual fell to the ground. So in that case, the Supreme Court did rely upon the common law doctrine, Good Samaritan doctrine set forth in the restatement of torts.
Is that your case in chief?
Well, there are a lot more cases, okay? There are a lot more cases. Let me talk about one other case. And there are several cases where there are competing issues of liability, of civil immunity based upon the status of the entity. And this case is another Supreme Court case. And it was decided under a couple of different laws that provide immunity from civil liability. It's called Register versus the County of Chester.
Now, Ken, pardon my interruption. And by the way, I assume this green light means we are picking this up. Okay, so just double checking. Before you get into that case, so now we're transitioning from common law, Good Samaritan doctrine, into statutory forms of immunity. So do you want to tee up for a second the sort of the transition from common law to statutory immunity and maybe set that up a little bit?
Sure. So first of all, statutory authority for Good Samaritan civil immunity in Pennsylvania. There was actually a statute in 1965. I'm going to talk about one, though, that was enacted in 1976. So in 1976, Pennsylvania enacted the non-medical and medical Good Samaritan civil immunity statutes. And the non-medical Good Samaritan civil immunity statute provided civil liability immunity to policemen, to firemen, members of the ski patrol, National Ski Patrol, and to members of volunteer ambulance companies and volunteer rescue squads. And at that time, in 1976, there were no licensed ambulance services in Pennsylvania at that time. So they were provided protection from liability for their acts or omissions that caused harm to an individual at the scene of emergency when they exercised the duties that they were required to exercise based upon, them being a fireman, policeman, et cetera. And the standard was that they would be liable unless the conduct was due to their gross negligence, or if they had intentionally designed their conduct to harm the individual. Now, in addition to the requirements that it be a policeman, fireman, et cetera, there was also a requirement that they had to meet certain responsibilities that were set forth by the American Red Cross, education, training, and certification requirements. And so a layperson in 1976 couldn't use that statute if they provided care to an individual at an emergency scene, because they wouldn't meet that criteria. In 1978, that was amended, that statute was amended, and removed the language regarding firemen, policemen, et cetera, and inserted any person. So it's any person. In addition to that, they removed the requirement that the service that were performed at the scene of an emergency were the duties of that person. But what they didn't do is they didn't move the American Red Cross requirements, all right? They included the American Red Cross requirements and made an alternative requirements. It could be the American Heart Association equivalent requirements or the Department of Health equivalent requirements. And in addition, it provided that immunity only if the individuals provided the services that they were trained to provide and certified to provide. So that's the way it was in 1976, 1978 amendments. There was no protection for the layperson who didn't meet those requirements. Now we move to 2012 for the third and final amendment of that statute. And the amendment relabeled the statute instead of non-emergency Good Samaritan civil immunity to emergency response provider and bystander civil immunity. And under that statute, they removed all of the requirements dealing with providing care in accordance with a certification from the American Red Cross, the American Heart Association, or the Department of Health. So now, for the first time, an individual who didn't have any of that background, a layperson, had no medical training, they would have civil liability. They have civil liability protection under that statute as it was amended in 2012, provided, you know, they didn't engage in gross negligence or conduct that was intentionally designed to harm the individual. So that's the non-medical Good Samaritan statute. Let me just talk about the EMS provisions, all right? Because in 1976, there was also enacted legislation that expressly gave civil liability protection to EMTs and paramedics, all right? And also, with regard to paramedics, the statute listed certain procedures that if the paramedic performed those procedures pursuant to an order of a physician, they would also have that protection. So now, Doug, you had written a paper on that statute. Did you have anything else to add to that?
No, Ken and I were preparing for this, and I said, when I was a young man in college, I wrote a very judgmental paper on the status of Pennsylvania's EMS legislation in the early 1980s. Of course, that was then amended. So,
Yeah, so in any event, we move from that to the EMS Act that was enacted in 1985. And the EMS Act expressly provided civil liability immunity for EMTs, paramedics, and health professional physicians and nurses. And the standard was, you know, provided they didn't engage in gross negligence or willful negligence. And then in 2009, the EMS System Act was enacted, and it extended liability to a number of other parties. And the EMS System Act then included, in addition to the ones I previously mentioned, included pre-hospital registered nurse, pre-hospital physician extenders, medical command facility, medical directors. And in addition, this wasn't included in the 1985 Act, but was included in the 2009 Act. They included civil liability protection for EMS agencies, all right? And in addition to that, provided civil liability protection to the Department of Health, to Department of Health officials. Dylan, I'm sure you're you're happy about that, and employees, all right, with respect to harm that might be caused by EMS providers following Department of Health approved protocols. Okay, so that brings me to the register case. Okay, all right, so this is a 2002 case, also went up to the Supreme Court of Pennsylvania, and the facts are Register versus the County of Chester. And the facts are pretty simple. There was an individual who was experiencing cardiac arrest. The household called 911, explained the condition of the man, and gave the 911 dispatcher directions on how to get to their home. The 911 dispatcher then dispatched a volunteer fire company for BLS ambulance service and a hospital for ALS ambulance service. and provided the directions, the driving directions that were given to him by the caller. And unfortunately, the two ambulance crews did not follow those directions. So ultimately, they got to the house, but later than they would have if they followed those directions. And they were not able to revive the man. So after that, then the estate and survivors brought a wrongful death and survivors action in court against against all kinds of defendants. All right. But the case before the Supreme Court only dealt with the possible liability of the volunteer fire company and the hospital. So both entities claimed immunity. All right, I'll deal first with the volunteer fire company. The volunteer fire company claimed immunity under the Political Subdivision Tort Claims Act, which protects local agencies, and they contended that they were a local agency. The plaintiffs, argued, no, they're not a local agency, all right, protected under that statute. But even if they are, all right, they're still liable under an exception to immunity under the Political Subdivision Torts Claims Act, which was the operation of a vehicle. All right, well, the Common Pleas Court decided, yes, they were a local agency. They did have protection under the Political Subdivision Tort Claims Act, and that they did not have liability under the vehicle liability exception because the court concluded that in order to do that, in order to have liability, you had to actually cause harm by the movement, by the driving of the vehicle. All right, so
I'm sorry, Ken, to clarify, getting lost or being delayed is not necessarily, even though you may be in a vehicle when that happens, that is not related to the use or the operation of that motor vehicle.
well, that's what the Common Pleas Court held, but the Common Pleas Court also held that operation of the vehicle means that it has to be moving, all right? Because that exception to liability had to be narrowly construed, and they determined that the narrow construction of that exception required that the vehicle had to be moving, all right? So the plaintiffs then appealed that decision to the Common Pleas Court. And the Common Pleas Court affirmed, but the Common Pleas Court made a distinction regarding.
So you mean the Commonwealth Court?
I'm sorry, Commonwealth Court.
Just clarifying, thank you.
Yes, the original decision was the Common Pleas Court. The appeal was to Common Pleas Court. The appeal was to the Commonwealth Court. So the Commonwealth Court said that, they agreed that this entity was, the volunteer fire company was a local agency. But with regard to the vehicle exception, they said, well, it's a little bit more expansive than driving, than just the harm that's caused by driving the vehicle. But nevertheless, the exception had to be narrowly construed, and they determined that, not following the directions, which may have, driving directions, which may have resulted in harm, was a not sufficiently narrow construction of the statute. So again, they affirmed the Common Pleas Court decision, but made a little bit of a distinction. But the plaintiffs then filed a petition for allowance of appeal to the Supreme Court. Appeal was granted, and the Supreme Court, the Supreme Court considered the same matter and affirmed the decision of the Commonwealth Court. However, two of the justices of the Supreme Court dissented from that opinion, and they would have held that not following the driving directions that may have resulted in harm would be covered under the vehicle exception. So that was a kind of strange dissent, but that's the way it went. Let me move on to the hospital. So the hospital also claimed immunity, but they couldn't claim immunity under the Political Subdivision Tort Claims Act because they weren't a political subdivision. They claimed immunity under the then EMS Act, the one that was enacted in 1985. Now, as I mentioned before, the EMS Act mentioned specific EMS providers, EMTs, paramedics, etc., didn't mention an ambulance company or an employer of those individuals. But the Common Pleas Court relied upon an earlier Common Pleas Court decision, which said that notwithstanding that, because the employer only functioned, the entity, the corporation only functioned through its employees, they would have that same liability. They would have, I'm sorry, the same immunity from liability. And that was appealed to the Superior Court, which affirmed that decision. Okay, so now we go, the hospital was granted summary judgment by the Common Pleas Court. The plaintiffs appealed to the Commonwealth Court. The Commonwealth Court reversed. The Commonwealth Court determined that, well, look, the EMS Act specifically mentions individuals, EMTs, paramedics, etc. That didn't mention an employing agency, didn't mention an ambulance service. Or hospital, if the legislature had wanted to protect those entities, it would have done so. Okay, now they also, the Commonwealth Court also considered a prior decision of the Supreme Court, where the Supreme Court had granted immunity to an employing agency under the Mental Health Procedures Act. All right, but in that act, even though the statute mentioned certain individuals, it also said, and any other person. So the Supreme Court looked to the statute, there was no definition of person. So they then looked to the Statutory Construction Act, which defines person to include corporations, limited liability companies, associations, etc., unless the context clearly indicates otherwise in the statute. And the Supreme Court held, no, the context didn't clearly indicate otherwise. Now, the Commonwealth Court considered that case, but distinguished that case because the EMS Act did not include a provision that said any other person or similar language. And then that decision was appealed. The Commonwealth Court's decision was appealed to the Supreme Court. The Supreme Court affirmed and also agreed with how the Commonwealth Court had distinguished its earlier opinion under the Mental Health Procedures Act. Let me just say one more thing about that. If this case had been brought today, it's very possible that the hospital would have protection under the current EMS System Act, because under the EMS System Act, civil liability protection is given to EMS agencies, to licensed EMS agencies. So Doug, I think that's about it.
Okay, thank you, Ken. I was negligent in my moderator duties because I did not introduce Ken properly before he took the podium. Ken, sorry to say this, but for several decades, 30 years, I think, Ken, was senior counsel at the Pennsylvania Department of Health. I think you were chief counsel for a portion of that. And also prior to that was counsel with the Pennsylvania Department of State, the Bureau of Professional and Occupational Affairs, which licenses most healthcare professionals in the Commonwealth. And since 2000 and what year did you come to us?
2011.
11 has been of counsel with PWW. So one of the things Ken did among his other duties at the Commonwealth was you were the principal author of the current EMS regulations and the act, I believe, as well. So he knows of what he speaks. So thank you, Ken. Ryan and Matt, do either or both of you have some prepared stuff to say, or do we want to just jump into the discussion?
No, let's jump right into it.
Okay.
Yeah.
The first question I'd like to pose, and I'll ask either Ryan or Matt to jump in. I want to sort of first focus on the fact that immunity in the Commonwealth is, for a defense lawyer, and I guess for a plaintiff's lawyer, if you're trying to get over the hurdles of immunity to establish liability on the part of defendants, is now a patchwork or a potpourri of both statutory and, while this Ken didn't mention this, common law, those common law doctrines, I believe, are still in effect, still recognized in the courts of Pennsylvania. So can we talk, or can one of you speak a little bit about sort of, Ken mentioned the Pennsylvania local government tort claim immunity for local agencies. And we talked about EMS statutory immunity, but do either one of you sort of want to talk about the array of immunity provisions that defense attorneys can avail themselves of in cases in the Commonwealth? Ryan?
Sure, I'll kick things off. And as you mentioned, there are several. And if I'm, the defense attorney defending the potential tortfeasor, the individual against whom they're bringing the action, I'm going to try to avail myself to any and all potential immunities that are available. So if they're acting within the scope of, the EMS Act, then I'm going to try to avail myself to immunity under the EMS Act. And that immunity is pretty strong. There's a pretty high bar. And I just want to get into too, just as a general matter, for those non-lawyers who are joining us today, what immunity laws do is they make it more difficult for somebody to sue somebody for liability in these cases. So you have to prove a higher bar. Instead of regular type negligence, they have to prove gross negligence on behalf of that party. And that means it almost looked like they tried to harm and cause the harm to that individual. So why do we have immunity? Well, as Ken mentioned earlier, Good Samaritan immunity derives from the fact that there's no duty for me to help thy neighbor, if I see thy neighbor in peril. But if I do help thy neighbor, we don't want to hold that person responsible, except if they intentionally tried to harm that individual. So there are good intentions behind those laws. Same thing with the EMS Act immunity. The reason we want to cloak our folks with that type of immunity is so they want to engage in these type of activities. They want to help them without fear that every little thing that they do is going to be called into scrutiny. They could be sued for that. So as Doug mentioned, if I'm the defense attorney, number one, if they're acting within the scope of the EMS Act, I'm going to try to avail myself to that layer of immunity. And that's a pretty strong layer of immunity. And we can talk about that in just a moment. But the Political Subdivision Tort Claims Act immunity as well, if they are a local government agency, i.e. they are town of, city of, and they're a municipality, there are implications behind that. And the reasons for immunity for a municipality is, after all, the folks who have to pay for that settlement, if our providers are sued successfully, are the taxpayers of that community. So there's a rationale behind that, but there's a whole different set of common law that says when we get protection under that portion as well. And the Good Samaritan Act is actually broad enough to cover providers as well. So I, as the attorney, would want to raise all three layers of immunity. And if any of those stick, I get the benefit of the plaintiff now has to prove that my providers were grossly negligent. So we talk about that in law school and try to parse that out. It's really hard to define. It's kind of like, I know it when I see it, and we can talk about, we'll probably talk about some case law about when it does rise to the level of gross negligence. But regular negligence is, I pulled up to the stop sign and, I looked several times and proceeded through, and I was just kind of careless. I should have taken off. Gross negligence means I rolled up to the stop sign, didn't even come to a stop, and I pulled out and I hit somebody. So there's a difference there. There's a little bit more of, there's a higher bar, and that's what they have to prove. So there's several layers of immunity to which the.
Thank you.
defendant can
Yeah,
avail
Steve, I know we'll be talking a little bit later about the sort of delineation between ordinary negligence, gross negligence, and intentional misconduct, even potentially rising to the level of criminal liability, which is really what's weaving into the fabric of the conversation now. Matt, I'm going to put you on the spot here because one of the things that I think is interesting is that we seem to have conflicting public policy that underlies immunity. On one hand, as Ryan said, we want to incentivize people to become EMS providers, right? We want to give them some layer of protection so that their actions or omissions, if done in good faith and not to the level of gross negligence that Ryan talked about, will be given some protection in the law. But according to what Ken said, in courts will also look at the immunity provision somewhat narrowly because they kind of are in derogation of the common law, right? That injured plaintiffs deserve a remedy. So I was wondering if we might put you on the spot to talk a little bit about public policy underlying, and there can be opinion in here too. Where should courts and the General Assembly, for that matter, draw that or find that line between wanting to protect first responders and to have accountability for people who are injured due to their actions. Any thoughts on that?
Actually several. And I think the most important thing, and the thing I want to start off with, and it's touching off something Ryan talked about. In EMS classes, in paramedic school and EMT school, we're taught about negligence probably for a total of 5 minutes. It is mentioned in a program somewhere and it says, hey, basically, if you're an EMS provider, you have protections against liability. So that does kind of encourage people to come into the field. But what I'm getting to the bigger point is there needs to be almost more education for EMT and paramedic students and talking about these public policy determinations, because I'm willing to bet if you go into the field, and I'm a field provider myself, and I know my coworkers, if you ask them, can you tell me what gross negligence is? If lawyers and courts are wrestling with that theory, field providers in EMS are also going to have almost no real idea of what's the difference between negligence and gross negligence is. So weighing that all together, and especially looking at the public policy aspect of it, it is almost a razor thin line. We really do want to encourage people to come out, people to volunteer. A lot of EMS agencies in Pennsylvania rely on volunteers. A lot of fire departments especially rely on volunteers. So you want to encourage people to come out. But on the flip side of that, you also want to make sure those people coming out are trained and have the ability to perform the jobs we expect them to perform. So there is this thin line, and there's this balancing of the need for the Commonwealth to ensure that people are receiving proper emergency medical care in the field, while also encouraging people to volunteer. So I almost think personally, we have to put it right down the middle. We need to have the strict interpretations of EMS Immunity Acts, of Good Samaritan Acts, so we ensure that not everybody out there that may be a bad provider or may have some issues and perform substandard care and get away with it. But on the flip side, they can't be so strictly interpreted that anybody on the street goes, whoa, I don't want to get on an ambulance. I don't want to get sued. I don't want to have the liability. I make the most tiniest of mistakes and I'm going to have an issue. So there is a very fine balancing point. And where that actual balancing point is, I think that can be a symposium, a day-long symposium of itself, trying to figure out exactly where that line needs to be. But obviously there are very strong public policy reasons behind immunities. And if you look at it, one thing I thought was funny, I was doing some research last night, and obviously this symposium is limited to Good Samaritan immunities and EMS immunities. But if you look in the immunity section of the Pennsylvania statute, there's Good Samaritan immunities out there for almost anything you can think of. Coaches, veterinarians. So there is a strong public policy to have these protections for individuals. So these individuals will come forward, will serve their communities. But again, we can't have them so liberally interpreted that, well, you know, you made some mistakes. There were some really big mistakes, but we don't think this raises to gross negligence. We're just going to move on. So there is that balancing mechanism that has to take place.
Well, thank you. And continuing my negligence as moderator,
In the newest version of the Good Samaritan liability, I believe there's specific wording there regarding automatic exterminator. Is that the same act? And is that pretty widely accepted? Have there been a lot of cases about that? We support a bunch of programs in our community and kind of worry a little bit about
I just ran across this.
A different statute.
serious liability down the line about, they didn't come out and check this month, et cetera, et cetera.
Yeah. So let me first repeat the question, and that question is, can we comment on the status of Good Samaritan immunity specific to AEDs, automated external defibrillators, which of course are now proliferating, thankfully, in more and more public spaces, including here, where you can pull one off the wall and help resuscitate somebody who suffers an out-of-hospital cardiac arrest. I have strong thoughts about AED civil immunity, but I saw some conferring over here. Is one of you prepared to
Well,
start off?
yeah, I just wanted to say that, yes, there is a statute that deals with AED, kind of Good Samaritan civil immunity. It is not the same statute. This is not the same 2012 amendment of the former good, non-medical Good Samaritan statute. It's a separate statute. And as Matt has indicated, over time, the Commonwealth has really expanded the concept of civil immunity protection for people who volunteer or even people who are paid to provide certain services. And there are a lot of Good Samaritan types civil immunity statutes in Pennsylvania right now.
And, the same public policy there, particularly with AED, underlies, we want people to grab a defibrillator off the wall and put it on a person who has an out-of-hospital cardiac arrest. And if people don't do that for fear of liability, we've got preventable death on our hands as a society. But I will say in response to that question that one of the, I think, Achilles heels of immunity, not just in Pennsylvania, but in many states is, you may heard Matt say that we have many constituencies that have specific statutory immunity. Well, folks, that statutes are passed by the General Assembly. That's a political operation, of course. These interest groups come to the legislature and they say, we want this protection. Now, you heard Ken say that in Pennsylvania, in some cases, that statutory immunity is premised on having a card in your wallet. Now, the American Red Cross and the American Heart Association have done good work in the country, but their names are ensconced in that statute because they are also proprietary providers of courses that generate revenue. And to say that you have to hold those cards to be eligible for that statutory immunity, there's a self-interest baked into that. I think the equivalent is to say, to grab that fire extinguisher off the wall when there's a fire in the building, you have to first go through fire school or training to do that, right? When these devices are almost idiot-proof. Now, when you say something's idiot-proof, along comes a better idiot. So I understand that. But the point is that we really don't want to have barriers or obstacles in the place of people acting. We're not going to make a cardiac arrest victim any debtor by not having a card in our wallet. So I think that there's an Achilles heel in that statutory immunity that is sometimes held hostage to proprietary interests. And that is a competing public policy issue that is a byproduct of the fact that statutes are generated in the General Assembly, which of course is political and subject to those interests. I'm not saying they're evil, but I'm saying there is the business aspect here too, I think, that is often unrecognized in Good Samaritan immunity. We're out of time for this panel, but we do have two questions. I'm going to address them extremely quickly. Great questions, so I appreciate that. The first one is the Good Samaritan Acts and common law cover those that sort of incidentally come upon a scene. How does that cover someone in EMS who goes directly to a scene after hearing about the incident via scanner or pager, thus changing the response to sort of purposeful as opposed to incidental? That's a fantastic question. And I will tell you that, and Ken and I sort of overturned an old county common pleas case.
Dauphin County.
Dauphin County here where we're sitting, that the courts are now, I think, becoming more skeptical about applying Good Samaritan layperson immunity and even common law Good Samaritan immunity to trained responders. And I think it's less whether you had a legal duty to engage in the act, which in this question, the fact pattern is that you didn't have that legal duty, and more that if you are sort of a professional responder, regardless of your pay grade, that you hold a certification, that common law Good Samaritan immunity and that non-medical Good Samaritan immunity, courts are less likely to want to apply that. And I think your primary protection, to the extent there is any, now would be statutory under the EMS Act by virtue of holding that certification. So I think there's a narrowing of immunity for trained and certified responders. The second, does anyone disagree with that?
I wanted to add something to that.
Go quick, please.
Just that case, the Dauphin County case, two paramedics tried to defend against the charges based upon both the non-medical Good Samaritan Civil Immunity Statute and the EMS Act. And I don't know whether this is good law, but the Dauphin County Court said you can you are protected under the EMS Act, but you're not protected under the non-medical Good Samaritan Civil Immunity Statute.
Thank you.
Again, that's a Dauphin County, that's a common police court. I don't know of any appellate decisions beyond that, but.
Right. And just very quickly, the last question is also a great one. Where does it fall if a certified provider fails to provide care while off duty? So in Pennsylvania and nationally, there really is no affirmative obligation on the part of a bystander or even an off-duty EMS practitioner to act. It is a voluntary undertaking. So if I hold a certification and drive right by the scene of an accident where there are clear injuries just based on how mangled the vehicles are, I'm free to do that. I'm free to drive by that scene. So I think it's always important to contrast the concepts of a legal duty with a moral one. And when we talk about moral duties, the law gives all of us the ability to make a decision in that circumstance based on our own values and judgments, but does not impose that obligation. And those immunity statutes do provide a bit of incentive that recognizes that that's a voluntary undertaking. And here's a little bit of incentive to encourage you to do that. So that idea of a voluntary undertaking is really built in to the premise of those Good Samaritan statutes. And no court that I'm aware of has ever imposed upon an EMS provider, either in the Commonwealth or nationally, a duty to act when not engaged, right? You're not at the station, you're not on shift. That may be a different question. And courts, by the way, have also analyzed that under something called the public duty doctrine, which might even suggest that an EMS agency, once called, may not even have a duty until they actually engage the patient, which is again called the public duty doctrine. So I would say in that tug of war between public policy of accountability and immunity, it has generally skewed toward immunity, and that pendulum may be shifting. So with that, gentlemen, thank you for your thoughts on this panel. And if I could please ask the next panel to get right in place, Christina, Wirth, and while they are taking their place, I will now properly introduce them before they speak, starting with Steve Wirth. I think you'll be first up, Steve.
Yeah, I think so. You're gonna queue up the slides.
Yeah, Brian, is Brian handy? He'll get it broadcasting on the Zoom.
Great.
What?
Here's Brian. Thank you, sir.
No, it's chilly.
So Steve Wirth is a founding partner of Page, Wolfberg, and Wirth, a 1994 graduate of Duquesne Law School. We won't hold that against him.
Thank you.
And someone that I've known from our EMS days in the 1980s. And then we became law partners in 2000 when we started PWW. Steve is a paramedic and was the founding chief operating officer of Emergicare in Erie, one of the largest ambulance services in the Commonwealth of Pennsylvania, was both a ground paramedic and a flight paramedic. Christy Malott is a senior counsel, senior attorney at PWW, has been with us since we started in 2000, and also an EMT and former emergency room technician, and is graduated from Temple Law School. I got that right. I believe I recall that. And again, has been with us for 21 years. So Steve and Christy are going to now shift gears and talk about employer regulation of EMS provider conduct, both on duty and off, touching on areas of free speech, social media, mandatory vaccinations, which is very timely, and more. So Steve, take it away. Thank you.
Thank you, Doug. And it's great to be here with everybody. I'm just going to tee up the topic because let's face it, this is probably one of the most challenging issues we're all facing today in the EMS world.
dealing with our workplace, especially when we're dealing with a situation where we are losing EMTs and paramedics. The attrition rate is extremely high, and there's this great attrition nationwide with people leaving their jobs, but it's particularly troublesome in our field because fact is we're just overworked, underpaid, and stressed out. And we have to balance that with, well, as an employer, how do we hold everybody's feet to the fire? We still have standards. We have to provide effective patient care. And we got to make sure that we call out people when they engage in bad behavior, and we recognize them when they engage in good behavior. So that's really the dilemma here, is kind of balancing all of that. And, what does the law say about what your rights are? And we're going to get into the differences there depending on whether you're a public or private employer and so forth. But I can tell you that when we handle employment cases and questions that come into the workplace, I know Christy and I were talking about this earlier, one of the most common calls we get is somebody will call us up, one of our clients or EMS agency, and they'll say, the first question out of the box they ask us is, well, we have a situation. I have a question though, is Pennsylvania still an at-will employment state? When they ask that question, we know that something's already happened. They've already terminated somebody or done something adverse to their employment. And now they slept on it overnight. Now they want us to, affirm that everything they did was fine, right, Christy? Dig them out of the hole. Sometimes we cannot do that, unfortunately. So when in doubt, always call your lawyers, especially the ones who are experienced in employment and workplace law. So we're going to touch upon employee free speech and the rights of public versus private employers. And we'll get into some of the hot topics. Social media posts. Hey, everybody is out there spouting on social media. I think probably a lot of our problems in the workplace could be resolved if we just shut off social media and it was gone, okay? And then we get into all the issues of privacy rights and some of the stupid things that people do. Good people do stupid things. And occasionally in a rash of emotion, they'll type something in there and then it goes out to the world. So we'll talk about that and what your rights are as an employer. And then we save the best for last, mandatory vaccinations. Well, I got the right to protect my body and decide what goes into it. I don't care what job I have in society. Well, as we're going to tell you, that isn't true exactly. So we'll get into the issues there. So with that, I'm going to hand it over to Christy, and she's going to start it off with free speech. How about it?
Free speech can be expensive.
Yeah.
All right, so with free speech, we've got two different topics. We've got public agencies, and one rule applies to them, and we've got private EMS agencies, and another rule applies to them. So with the First Amendment, the question is, how far do the rights go? Well, if you're a private EMS agency, you generally do have the right to terminate someone. They don't really have any free speech rights. But there is something to remember, which is there is Title VII, which protects employees against harassment and discrimination based on sex, religion, age, national origin, veteran status, all of those good things. You want to make sure that you're not relying on, well, Christy told me that private EMS agencies have the right to terminate someone and employees don't have free speech rights. Well, let's say you have an employee who wants to re-energize the Black Lives Matter movement and post something on social media in support of re-energizing the Black Lives Matter movement. It would be very bad for you to terminate that employee for doing that because you're going to backdoor yourself into a race discrimination claim potentially. So you want to be careful on just simply relying on the fact that in general, private EMS agencies, which includes not for-profit EMS agencies, as well as nonprofit EMS agencies, even if they're designated by a municipality as the primary responder for that area. So you do want to be careful on just terminating someone who's posting something because you're relying on the fact that you're a private EMS agency in doing so. And then there's also a question on the extent to which you as an employer can regulate on and off duty. So that's private EMS agencies. With public EMS agencies, and this would include municipal providers where the city, the township, or the borough itself is the one providing services. The rules are a little bit different, and employees do have some First Amendment protections They have the right to speak out on matters of public concern. It doesn't extend to matters of private concern, and it doesn't extend to criminal conduct. And if Steve's going to talk about in a minute, criminal conduct and private concerns, let's take, it includes actions and inactions. So the insurrection at the Capitol, because people that broke into the Capitol building were committing a crime, that doesn't include that is outside the extent of First Amendment protections because it's criminal conduct. So when we look at matters of public concern, this comes, for all of you lawyers in the room, from the Pickering test, which is 2 U.S. Supreme Court cases, one in 1968, Pickering versus the Board of Education, and then Connick versus Myers in 1983, looked at the Pickering test again, and they are the ones that decided the matters of public concern. Is the employee speaking as a private citizen on a matter of public concern, even if they're employed by a public agency? And does that person's interest in commenting on matters of public concern outweigh the interests of the government in promoting the efficiency of the public services it performs through its employees? If so, then the public agency employee does have the right to speak about them. Steve, did you want to
Okay,
take
cool.
over and tell people about this some
Sure
more?
thing. Okay, well, starting with the basic premise in Pennsylvania, pretty much Pennsylvania is an at-will employment state. We'll get that out now. And going back to a Supreme Court case, Henry versus Pennsylvania Railroad in 1895 established that. And that basically says that employers generally can terminate an individual, an employee, for any reason, no reason, good reason, bad reason, whatever reason at all, as long as it's not an unlawful reason. Because the whole concept is premised on it's a bilateral relationship. The employer hires you, you get money for the work you do for the employer. You also have the right to leave that employer at any time, and that's the basis of it. So in terms of constitutional rights, you really don't have any constitutional rights in the private workforce, in the private sector, okay? Some limited, very limited constitutional rights in the public sector. And that's this balancing that occurs. And I can tell you that most federal cases involving this balancing, the balances between the employer's right to maintain stability in the workplace and order in the workplace and discipline and morale and all that, versus the individual's free speech rights to speak out. The rights the employer has there are pretty strong. And most of the cases tend to favor employers in these free speech cases because efficiency of the public service really is looked at as a very significant concern. Now, what's a matter of public concern that individuals who work for public sector agencies can speak out about? Well, it has to involve political, social, or other concerns, something that affects the taxpayers is my sort of litmus test for that. Is this something that the taxpayers want to know about, okay? Is it something of concern to the citizenry? Because it's the government that's providing that public service, whether it's police, fire, EMS, and those particular organizations. So you got to look to that. And most of the times, it is not a matter of public concern that employees are speaking out about on Facebook or in a public situation or whatever. And yeah, that can extend to their speech, written comments, editorials, commentary, their actions like the insurrection that Christy talked about, inaction, attendance at an event. You know, some employers were disciplining employees who were present in the Capitol area on January 6th, even if they didn't do anything specifically, okay? So yeah, there can be some free speech rights there in some situations. But complaining about personnel issues, grievances against the employer, I don't like my boss because he's a jerk or she's a jerk, that type of thing is generally not considered free speech. So disruptive statements that impinge on morale and the efficiency of the workforce, not free speech. So a lot of confusion here because especially today, when we're dealing with this mandatory vaccination issue, everybody thinks they've got constitutional rights, right? Okay. Yeah, they don't extend to the private workforce. And in Pennsylvania, most of our EMS agencies, to bring it close to home here, most of our EMS agencies are not public agencies. Most of them are nonprofit corporations, okay? Not-for-profit corporations or for-profit corporations. No constitutional rights in the workplace there. So with that, there is no unfettered right to complain about your boss, okay? You can complain all you want, but the boss also, even if he's a bad boss or a jerk, as long as he's not being an unlawfully discriminatory boss. By and large, that's a situation that sometimes you have to deal with or make that decision. And that is, maybe you don't want to work there any longer. That's the other aspect of this. Okay, now social media, let's get into that because, wow, this is a big area. Am I up or am I? Oh, I'm sorry. I'm still on deck. Okay. Well, let's face it. We could probably implement a 12-step program for people who are addicted to Facebook and social media because it is consuming everybody's lives. It's sort of like crack cocaine and it's getting out of hand. And what we got to recognize is we're dealing with issues here relating to when we look at the EMS agency itself, your organizations. Hey, both public and private entities have a legitimate interest to make sure that social networking is used in a way that, one, doesn't violate patient confidentiality, doesn't harm the agency's business interest, or interfere with the work of others. Now, that doesn't seem like a whole lot to ask, does it? But that's where we run into the problems. People doing these sorts of things and they forget. And one of the things EMS providers at the EMT, paramedic level, and what have you, they sometimes forget that they have a professional obligation. That's a duty we have, a professional duty to make sure that the way we use social media is done in a way that doesn't violate patient confidentiality, harm the agency's business interests, because that's our employer or the agency we volunteer with, or interfere with the work of others. And I add to this that it should reflect favorably on our professional status. I think that's an obligation that we all have. And the fact of the matter is that, yes, employers have a lot of leeway in terms of discipline and taking actions against individuals who spout off on Facebook that violate these things like patient confidentiality, interfering with the business interests of the company, and interfering with the work of others. So let's take a look at two Facebook posts here just to kind of contrast this. Let's assume this is a public agency. And again, there's not that many public agency EMS operations in Pennsylvania. There's some that are fire department based. City of Pittsburgh's an example where there's a separate third service EMS agency. That's a public agency. City of Philadelphia and a few other places. Okay, so one of those public sector employees posts on Facebook, I hate working at Podunk County EMS. My boss is a jerk who doesn't understand EMS and comes down on me for no reason. Is that a matter of public concern? Do the taxpayers, are they going to be interested in that? Does that involve pretty heavy social issues that, you know, boy, the taxpayers would want to know because they want to take some action against that agency? No, that's a personal gripe, okay? And it can be disruptive to the workforce. It could undermine authority. And we are sort of paramilitary. We have to have authority and we have to have cohesive work relationships. So no, that's not a matter of public concern. But let's say that public sector EMT posts on Facebook after he or she gets home from work and says, you know, the Podunk County commissioners need to adequately fund EMS. Their budget cuts make it hard for us to provide the level of service the public has come to expect. You think that's a matter of public concern? Absolutely. And that would be a post that we probably would not want to discipline that public sector employee over, because yes, that's something the taxpayers are interested in. It deals with safety. It deals with the entire community. It deals with really what the government's all about in terms of providing public safety. And this person works for that agency. They got an inside track. Yeah, that's a matter of public concern. So you got to tread carefully. Now let's get into some of the areas where we're seeing a lot of EMTs and paramedics getting in trouble, okay? One Facebook post is a quick way to lose your job and end a really nice career in EMS. Well, in Tennessee, Leon Raymond, farmer, chicken farmer, went out to his chicken coop one morning and collapsed. He had a cardiac arrest. His family was there. They called 911 and the EMS came. They attempted to resuscitate him. He was in the chicken coop, okay? Among the bird droppings, well, one of those EMS practitioners decided to post on Facebook, well, we had a first. We had worked the code, cardiac arrest, in a chicken coop, knee deep in chicken droppings. Yeah. Poor Mr. Raymond died. He didn't make it, okay? Didn't survive. And then in a subsequent comment that this EMT made, he said, yeah, you know, it was really awful. You all could probably smell us all the way at dispatch. Yeah. Now, is that an appropriate kind of thing to say about a human being who just lost his life? He had a wife, he had kids, he had grandkids. And that's exactly what the family member said when they went to the news media. He said, what's going on here? We expect our public servants to at least have some common sense and decency, okay? But we get tainted. You know, we see a lot of bad things in EMS, police and fire, and sometimes we forget and lose sight of the fact that we really have to always, at all times, respect the dignity of other human beings. And they didn't do that in this case, no question. Would you discipline somebody over that? Absolutely. I don't care if it's on duty or off duty. I think the employer's on pretty good legal ground for disciplining an employee. And not only that, it could probably violate HIPAA here because you know it's a code, so it's a cardiac arrest. The dispatch information is probably public, so you're probably revealing patient information as well. Does anybody remember the show Emergency back in the early 70s? Okay. Ooh, great. I see smiles. Well, sort of smiles. I can't see them through the mask. But anyway, I see the nice bright eyes there. Yeah, some of us got into EMS because of this show. Johnny and Roy, okay? And our late great partner, James O. Page, was a consultant to that show. How about Roy getting off work? You know, now Roy and Johnny were professional all the time. They didn't really engage in, other than some pranks at the firehouse, nothing that affected the dignity, was adverse to the dignity of the human being. Well, Roy, you know, did something stupid. What a gnarly trauma call we had midnight on the 405 around milepost 64. That driver's leg was a bloody mess. Took an hour to get him extricated. Boy, he looked like road pizza. I heard they amputated his leg. Whoa. Now we got a big fat HIPAA violation, very unprofessional. And then we got, you know, Johnny's involved a little bit. And finally somebody says, Captain Hank Stanley, hey guys, this is an appropriate place to do that. And Roy says, relax, Cap, we didn't identify the patient. Oh, well, yes, you did. Okay. Because everybody's going to know that that truck driver for the news report, police report, 405, milepost 64, doesn't get much closer than that. So, and not only that, it's just plain old unprofessional. So the bottom line is we got to make sure we never, ever post image or make comments about patients, even if we think we can't actually identify the patient, even if we don't use a name or a specific address, because the law says, the HIPAA regulations say, if an average person can reasonably identify, if there's enough information to reasonably identify the patient, that would violate HIPAA. And HIPAA applies to pretty much all EMS agencies in Pennsylvania, public, private, whatever, because you're billing for services, and that's what gets you to be a covered entity under HIPAA. So think before you post is what we tell everybody. Take a deep breath and go, gee, is this the right thing to do? How does, you know, put yourself in the shoes of the patient and the family, which is what we should do on every single call. And if we did that, we wouldn't be committing violations. We wouldn't be negligent. We wouldn't violate HIPAA. How would you feel if that family, loved one, friend, or it was one of your friends or family? Would you like that? No. And the problem we have in our industry is a lot of us are adrenaline junkies, okay? Some of us got into this because, wow, this is exciting stuff. I saw this on TV. I could save lives. I could drive a vehicle with a siren and lights on it. So that's a high, you know, you get high on that a little bit. Some people can't control that high. But we got to remember that our high and that we enjoy doing this work, or we wouldn't be in it in the first place. That citizen we're responding to, that's probably the first ambulance call they ever had in their life, okay? That's a low for them. That's a bad news day for them. Their loved one may be dying. So our high in dealing with unique and interesting situations like the chicken coop case is the patient's low. And we always got to remember that. I think if we put it in that context, we stay out of problems. Am I still going?
Yep.
All right, great. So we have a duty under HIPAA to secure and not
Tracy?
disclose.
That was, nope,
Oops.
you're not still going.
Oh, sorry. Oh, well, then let me go back. What I do here? I screwed something up. All right, let me get out of the way here. All
There
right,
you go.
there we go.
All right. You know, while Christie's taking over the podium, one comment on something Steve mentioned. In Pennsylvania, you know, most EMS is not public. There are some notable exceptions to city agencies, townships, and boroughs that do provide EMS. By the way, I should also mention in Pennsylvania, we have municipal authorities, some of which provide EMS that are also public. But even though, you know, in most of our communities, if we see, the name of the town, you know, such and such ambulance service, that may be closely identified with the local government, but those are most often separate nonprofit, in some cases private EMS agencies that are separately incorporated entities. And I know that may sound a little inconsistent with what Ken talked about earlier in the register case, where the court concluded that one of those nonprofit agencies qualified as a local government agency. So what's interesting is that in some cases, courts will find the status of an organization to sort of be different depending on what issue the court is analyzing. So for some cases, those nonprofit corporations may end up being treated as public agencies, but in cases of free speech and speaking on matters of public concern, those very well might be private organizations in which the individuals do not have those so-called free speech rights. So it's an interesting schizophrenia, organizational schizophrenia, I guess. Last thing, Christy, and then I'll give it back to you. A reminder, if folks have questions on Zoom, you can put those in the chat, and Corinna is monitoring those. And anyone who has a question or comment can jot that down on their card, and Corinna will collect those, and we'll open it up to questions in a few minutes. Go right ahead, Christy. Thank you.
Okay, as Steve mentioned, there's a duty under HIPAA to protect patients' protected health information and not to disclose it. I know we all know that. And it includes documents, verbal comments, conversations, recordings. It includes images, even if you blur out the person's face, if they can reasonably identify the patient, it's included. And there's an interesting HIPAA violation that I saw that came out about 1.5 years ago that made me chuckle. And I want to share it with you guys because when I read about it, even though it doesn't involve EMS, I can totally see an EMS agency falling for this one. So we all know, hopefully are familiar with Yelp and the reviews and stuff like that. So a solo practitioner dentist, someone posted a 1-star review, scathing review of this dentist. And the dentist then, as you're allowed to do, if it's a post about you when you're the owner of the business, you're allowed to go in and refute the statement. You know, you get the statement of the owner. So the dentist went in and refuted the statements that were made by the patient who was complaining about the care on Yelp that he received with this particular dentist. And the Office for Civil Rights, who was the one in charge of enforcing HIPAA, gave the dentist a $75,000 penalty, which from HIPAA violations is really, really low. I'm sure it wasn't that low for that dentist, but it does drive home the point that like thumbs upping something when a patient says something about their care, even if it's positive, like, thank you for the care that you provided to me on the worst day of my life. I'm eternally grateful. Now, if you thumbs up that as the agency, you're not likely to get into trouble because they're the ones that posted it. And if they were that disenfranchised about it, they probably wouldn't have said something to begin with. But the thing I want to drive home is be very careful, because even liking and other things and commenting on things, when patients post them or people post them, you can backdoor yourself into a HIPAA violation, because for the lawyers in the room, we have a professional responsibility not to identify our clients without their permission. So we can't say whether you are a client if you're a client of ours, because it would violate our the rules of professional conduct as an attorney. Similarly, in EMS and in all healthcare, you have an obligation under HIPAA to protect patients' identity in the same fashion that we have to protect our clients' identity. So even when you like or dislike things or comment on things, you can be inadvertently releasing protected health information on your patients, which violates HIPAA. So avoid the improper use or disclosure of protected health information, and be very careful. Lost or stolen protected health information. I've seen people leave tablets on the back of the ambulance and then drive off. And even when they come back and try to get the tablet later, you know, usually the tablet's long gone. So that's a breach. Even if you have it secured and locked and someone needs a password to open it and stuff like that, if you can't find that tablet or that laptop because it fell off the back of your ambulance, you left it on the park bench, whatever, and it's not there when you come back, that too would be considered a breach. And you also want to be careful on posting images of patients. If you can reasonably identify the patient, then it's a HIPAA violation. Even if it's not a HIPAA violation, it's still improper to post things regarding your patients online. Just remember, from an ethical standpoint, it's their information, not yours. It belongs to the patients. And effective healthcare depends on the trust that patients have in all of you to provide EMS and healthcare services to them. Maybe you remember the selfie ward that took place down in Okaloosa County, Florida, where two paramedics were taking turns posting images of unconscious patients online, and they blurred out the faces, so you couldn't see the faces, and they thought that that protected them because if my face is blurred out, my family's never going to be able to identify me, right? Wrong. If you blur out the face, the person's family is always going to be able to identify them. And if somebody can reasonably identify the patient, even if the face is blurred out, then you've potentially violated HIPAA. And it's certainly not limited to just EMS agencies. Nursing homes and hospitals have run into problems with improper posting of photos online as well. To counteract that, what you need as an EMS agency is a clear company policy. You need to identify to your staff what they're allowed to post and when they're allowed to post. If you're going to allow people to post things on social media at work, you should limit it to during breaks or other downtimes. And your social media policy and your policy in general should be never post information about patients, and not when you're with a patient, not when you should be with a patient, and not about patients, not while operating or in company vehicles, even if you're the passenger in the passenger seat of the company vehicle, and not posting when work is being done or should be being done. So this is also an
Christy,
action. Yes.
Pardon my interruption. On the privacy issue, I think looking at the rest of that material, I think we've kind of made those primary points. Do you mind jumping ahead, just in the interest of time, to the mandatory vaccination? Because given how timely that is,
Sure.
we'd like to make sure we leave adequate time for that, because that's a hot topic. And I think you kicked that off, Christy.
I do.
So go right ahead. Thank you.
All right, so jumping ahead to federal vaccine mandates. So as we all know, back on September the 9th, President Biden told us about 3 mandates. One was actually issued on September the 9th when he made that announcement, and that applied to federal contractors. He also promised us that we would be getting mandates for employers with 100 or more employees, and we would also be getting a mandate for healthcare employers of certified facilities who bill Medicare and Medicaid. The one that affects employers with 100 or more employees has not yet been issued. The one that applies to healthcare employers of certified facilities has also not yet been issued. The one that applies to federal contractors around September 24th, the task force that the president tasked with coming up with rules and policies on the enforcement of the federal contractor mandate said that the federal contractor mandate will not apply to healthcare providers solely on the fact that they bill Medicare and Medicaid. So all of you EMS agencies out there who might think that you're a federal contractor because you bill Medicare and Medicaid, good news, unless you have an actual contract, such as with a VA hospital, the federal contractor mandate won't apply to your EMS agency. However, stay tuned, because if you're a large EMS agency that has 100 or more employees, that mandate will likely be coming your way. The emergency temporary standard that OSHA issued to healthcare providers only took them 1.5 years after the pandemic to get out. So I don't know how long it's going to take them to get these out. They promised that both of these should have been out by now, but neither of them are, including the one for healthcare providers that was supposed to have been out by the end of September. But so stay tuned. The one that's going to apply to certified facilities whose employers bill Medicare and Medicaid, I can't tell you whether it's going to apply to EMS agencies or not. It's debatable right now. We're not going to know until we see the actual language. The OSHA ETS used the word certified facilities as well, and it applied to EMS agencies. So from that logic, I would think that it should probably apply to EMS agencies as well. Similarly, the link on CMS's website to certified facilities includes EMS agencies, but it may also only apply to entities with provider participation agreements, and that would limit its applicability to Medicare providers and not suppliers. So that would mean it would apply to hospital-based EMS entities, but not just standalone public or private EMS agencies. And that would be if it requires a provider participation agreement.
Pardon again, the bottom line on that, just for keep us moving, because we're at almost 10:30, is that we still don't know the contours of the potential federal mandate until there's more published on that.
We know the
And
Federal
make sure you
contract.
use the mic there. just-
We know the federal contractor mandate. We don't know the other two.
Thank you.
And remember, there's still exemptions for bona fide medical and religious reasons. If you have a religious reason, it has to be a sincerely held belief. All major religions we're aware of are endorsing getting vaccinated. And, if you practice the Muslim faith, they have an objection to some vaccines because they contain pig products. That's not the case with any of the COVID vaccines. They don't contain pig products. It's okay to ask people what their religion is. Social, political, and economic philosophies, as well as mere personal preferences, are not religious beliefs protected by Title VII. And for that, there's a number of people who are religious who have claim to have objections to the COVID vaccine because they claim that the fetal cells were used in the testing of the vaccine. They were. But you know what fetal cells were also used in the testing of? Motrin, ibuprofen, Tylenol, Benadryl, X-Lax, Sudafed. There's a whole long list, but basically aspirin. So if you've ever taken an over-the-counter pain reliever, then, or gotten the measles, mumps, and rubella vaccine, that's another one that, all of those have the same stuff. So if you have a religious objection to those, then you need to make sure that you're also not, you're putting your money where your mouth is and not taking any over-the-counter pain relievers, any allergy products, or anything if you have an upset stomach or anything like that.
So legal waiver by Advil is what you're saying.
I'm just saying, if you have an employee that claims that they're objecting because of the fetal testing, that I seriously doubt that they're all avoiding all the I seriously doubt they're all avoiding all of the over-the-counter pain relievers and stuff like that. So there is a medical exemption. Again, all of this, you have to look at a reasonable accommodation standard and what's an undue hardship. With a medical exemption, you need something from their physician that says that they need the medical exemption. And you need to engage in an interactive process and tread lightly for basically whether you grant or don't grant accommodations for medical exemptions. And I'm not going to go into detail because I know Steve has a lot to cover and we're running low on time. So Steve, take it away.
Okay, great. Thank you, Christy. Well, the bottom line is that employers can require employees to be vaccinated. Yes, it's a long history of that, going back to a Supreme Court case in 1905. And yeah, especially when you're dealing with public health and you're a healthcare provider. All of the cases basically that have come before the court pretty much have said, with rare exception, that when employees are advocating they got liberty rights not to be vaccinated, so forth. In this case, in Kentucky, the judge said the actual liberty for all of us cannot exist where individual liberties override potential injury done to others. And that's the concern here with unvaccinated employees out there taking care of patients and dealing with coworkers who need to be healthy and so forth. So this was an interesting quote the judge made, and it was a good one because it states it fairly well and accurately. If an employee believes his or her individual liberties are more important than legally permissible conditions of employment, like what uniform you have to wear, when you have to come to work and so forth, and to be vaccinated, that employee can and should consider choosing to exercise another individual liberty, no less significant, the right to seek other employment. So we think the law is pretty settled here. We'll see what's going to happen, though, in the coming months as some of these challenges trickle up through the courts. Some unique situations, if you have a unionized workforce, yes, mandatory vaccinations. If you are going to apply discipline and adverse action for people who don't accomplish it, yes, that could be a subject of bargaining. Ultimately, you can implement it, but you do have a duty to bargain, particularly over the effects and how it's going to be implemented and so forth. So let's go back to where these liberty interests all came about. This everybody's concerned about. Well, the irony of the whole situation is that George Washington was selected as commander-in-chief of the Continental Army in part because he'd already had smallpox. His face was scarred by it, and they knew he wouldn't get sick. Well, he required mandatory inoculation of the troops, not a vaccination, inoculation. Smallpox was rampant in the United States and England. It was a huge pandemic and people were dying from it, okay, including soldiers. So basically, he required them to be inoculated. Piercing the pustule of a person who had smallpox and actually putting part of that virus into a healthy person's body with a little incision or indentation in the skin, it's cut through the skin. Yeah, so they get a mild case and then they have an immunity. Yeah, ironically, that helped us win the Revolutionary War, which led to the Constitution, which gave us our liberty rights that we have. So those who are advocating their liberty rights, those rights were won by an army that was required to be vaccinated or inoculated by General Washington. In 1905, Reverend Jacobson didn't like the local law that required residents to be vaccinated against smallpox, and he refused to do it, and he refused to pay the fine. That went all the way up to the Supreme Court. And the court said that it is well within a state's police powers. Yes, states and local governments have police powers to protect the citizens, and local boards of health can do this. And when those mandatory vaccinations are needed, that requirement was not unreasonable nor arbitrarily imposed in this particular case. And one of the things he said was real liberty for all of us could not exist under the principle that, you know, basically we can do whatever we want as individuals without any, you know, thinking about what it does to others, whether in respect to his person or his property, regardless of the injury that may be done to others. No, we can't have a rational, reasonable society without that. So we're going to see what happens here. Most of the cases, as we said, are in favor of the employers, particularly healthcare employers. As Christy said, there is a duty to interact and to provide reasonable accommodation. Now, the duty under the religious exemption is an easy one for employers to meet, because the duty is you have to accommodate unless it is more than a minimal cost or burden to you, okay? So almost any cost or burden to the employer is justification not to grant a religious exemption. And a lot of healthcare employers are taking the position that we're not going to grant any religious exemptions because of that. And under the ADA side, under medical exemptions, yes, sure, there's some people who may not be able to take the vaccine, but the bottom line is that doesn't mean you have to put them in a frontline patient care position, because they could in turn pose a direct threat to themselves or others, okay, coworkers and patients. So it's interesting. There are duties there to accommodate it, but bottom line is pretty strong support in the law. Any questions on vaccinations in particular? Because that's a really hot topic.
Well, we do have a few here. One question is for federal contractors, are those mandates effective immediately or not until that becomes included in your federal contract? Do those federal agencies have to put that provision in your contract, or by virtue of being a contractor, will that mandate simply apply?
Right, by virtue of being an actual federal contractor, it'll apply when it goes into effect, and I believe that's early
December 8th.
December. Thank you, December 8th. So
Thank
for
you.
federal
All right,
contractors.
that was that question. One was about the role of unions play in these cases. You did touch on that. Another question, and there's one word I'm going to ask the person who wrote this one to clarify because I can't read it, but it says, in regards to social media and pictures of a blank posted on a web page proper, or I think it says, what's the blank? Picture. Incidents. Okay, thank you. Posted on a web page proper, have been seeing these done a lot on both EMS and fire websites. So if
Yeah,
you wanna
pictures
comment
of incidents like accident scenes and so forth. Yeah, you got to have a policy on that, and you ought to have some approval process, really. If it involves any patients, you know, that's a problem. If it doesn't involve patients and there's no license plate, it's all blurred out, that's probably not going to be a HIPAA violation. It's a matter of your agency and how you want that to be handled. The problem with allowing it, I can tell you from being in the fire department for many years, is people get more caught up into taking pictures that are pretty cool that they can post on social media instead of doing the work, you know, and they get distracted. So yeah, you got to have a good policy on that. Yeah.
But
Good
the other
question.
thing to keep in mind is, you know, if you are posting a picture of a terrible accident that happened, say on I-80, and you post the time and the date of the accident, everybody in the community, if you're in a small town, is going to know exactly who you're talking about and what happened because they all know each other. So, I mean, while if you can post to a certain extent, you got to be really careful on that, because if you're posting stuff that deals with medical incidents and people can identify who it was, simply by the information that's given out in the post, then you've basically told them too much and you might have a HIPAA violation on your hands.
Oh,
Right, yeah, if there's any suggestion or any concern at all, they shouldn't be posting it. And yeah, you can have a policy to tell them they can't post that stuff. Absolutely.
okay, folks, we are going to wrap up this panel. One just final comment. When Christy was talking about the example of laptops and tablets, which a lot of field providers use to enter patient data in the field, are left unattended or they disappear. One thing I do want to mention is that HIPAA does have something called a encryption safe harbor, that if those devices are misplaced but encrypted under sort of a voluntary standard, that is a safe harbor from the HIPAA breach notification rules. And our resident HIPAA nerd, Ryan Stark, would never forgive me if we didn't add that information. So we wanted to mention that as well.
So if it can't be accessed, it's not a breach.
Yeah, it becomes a paperweight instead
Yeah,
of a
right.
device if it's
Yeah, sorry, I should have
properly
clarified
encrypted.
that.
Yeah, no worries. So we're going to go ahead and take a break now, folks. It is 10:38, so we're just about back on schedule. We're going to take a 10-minute break. That clock's a few minutes slow till 10:48. We will start up again promptly then and begin. So those of you on Zoom, please stand by. You will see about 10 minutes of inactivity on your camera, but please stay with us and we'll be back shortly. Thank you.
Okay.
What happened with the sound?
There was a dog barking and
Because we are going to talk about the Pennsylvania EMS regulatory and legislative update. And there are some really interesting things in the hopper, so I'm going to make this as short as I can here. But I do want to introduce these folks. So first up on Zoom, we have Heather Sharar, who is the Executive Director of the Ambulance Association of Pennsylvania, making her third consecutive, actually all three of our panelists are making their third consecutive appearance in the EMS Law and Policy Symposium. So we really want to thank them all for doing that. As Executive Director of AAP, Heather really does spearhead the legislative agenda of the association. And I've said this before publicly, I'll say it again, Heather, sorry. But she has really been, I think, the most effective legislative advocate that EMS has probably had in its history, quite honestly. The things that her and the association have accomplished for the benefit of all EMS agencies and therefore the benefit of all Pennsylvanians has really been remarkable. And I want to give proper credit to the work that she has done and spearheaded in conjunction with the leadership of AAP. We'll turn it over to Heather in just a second. To my left, your right, is Jerry Ozog, who is the director of the Pennsylvania Fire and Emergency Service Institute, an organization which has been around for quite a while now. Yeah, 91, almost over, well, 30 years now. So, and PFESI has really been also one of the strongest and most effective advocates on Capitol Hill, and really from an educational standpoint to help educate public policymakers. And having the F for fire, as well as Emergency Services Institute, brings with it the strength of Pennsylvania's fire service, which quite candidly has always been stronger politically and has a louder voice, I think, than EMS has had historically, although Heather has been doing a great job of elevating the profile of EMS. But fire certainly has been long a constituency has captured the ear of the legislature, I guess is a fair way to say it. And last but certainly not least, over here to my right, we have Dylan Ferguson joining us again for the third time, who is the Commonwealth Emergency Medical Services Director for the Bureau of EMS at the Pennsylvania Department of Health. Also a EMS former, still current?
Still current.
EMS practitioner and a former ambulance service manager, director as well. So brings hands-on experience, which, you know, quite honestly, I think too few individuals at the state regulatory level have been there and done that and got the t-shirt. And Dylan has done all three. He's been there, done that, and got the t-shirt. And we were extremely fortunate to get somebody with his background and dedication. And I will also say, as far as state EMS directors go, he is one who takes his responsibility to be engaged and visible quite seriously, because I know you spend a lot of time on the road around the Commonwealth, visiting with EMS agencies, making appearances, speaking and supporting causes. Not necessarily, they're not a legislative advocate necessarily as state government, but is out there supporting the Pennsylvania EMS Provider Foundation, which Heather also heads up, Pennsylvania EMS Memorial Bike Ride, and just lots of activities that go on throughout the Commonwealth. So we thank you, Mr. Director, for your time and talents in being here once again. Okay, I promised I'd make it brief and then I failed. So let me introduce Heather Sharar once again, who is going to start off by talking about some of the legislative developments on the EMS side. Heather, it's all yours.
Thank you. Thank you for that very nice introduction. And it's great to be back, and we definitely appreciate Widener University highlighting the issues in EMS. I'm going to start out with the SR6 report. I did send a lot of links to some legislation and especially to the SR6 report. This is actually the second report that's been done on fire and EMS in Pennsylvania. The first one was SR60, which was done in 2004. So prior to that, at least 10 years, we've been sounding the alarm. We've been talking about the issues that are facing EMS. And I would be very interested in, Doug, your paper from the 1980s and the legislation that was in Pennsylvania, because I kind of feel a little frustrated because we have been talking about these issues. And one of the articles that I did send was an article that was in the NBC News, and the American Ambulance Association president was talking about the EMS workforce shortage. And he says, we are no longer bleeding, we are hemorrhaging. And that is very true for Pennsylvania. So if you look at the SR6 report, and I was actually a part of this, and Dylan and Jerry as well, in the introduction, this was actually before COVID. This was in 2018. A mix of long-term stagnant and declining reimbursements, limited other financial support, and changes to our societal view of volunteerism have negatively impacted EMS throughout the state, leading to EMS agency failures and closures. And I think that's very important because that was before COVID. Now, after COVID, and I'm just going to let you know about the Pennsylvania EMS Provider Foundation that Doug talked about, we were very fortunate to get a $10 million grant from Highmark. And I thought, wow, $10 million, that's great. That's really going to help. Except we had 554 applications that totaled $87 million. And I think that really highlights the financial struggle that EMS is facing in Pennsylvania. I only had 10 million that we could give. So if anybody has another 77 million, that would be absolutely great. So we talked about the decline in volunteerism. And I know Steve mentioned about the workforce shortage that we have. And in the SR6 report, Dylan was able to give us some statistics of active EMS providers, and this goes back to 2018. And active meaning they're actively involved, running calls, filing patient care reports. It was about 17,000 statewide, down, which was down at that point from recent estimates that were 30,000. So only 11,400 providers work for one EMS agency. Many work for multiple EMS agencies just to make ends meet. And it's very unfortunate that a lot of them make less than $15 an hour. There were a couple of attempts by the legislature, and even President Biden had talked about raising the minimum wage, which we did an impact statement on what raising the minimum wage to $15 an hour, how it would affect EMS agencies. Because not only would they have to increase the wages of EMTs that are making less than $15, then they would have to increase the wage incrementally for paramedics, for everybody else who was involved. And that's an unfunded mandate. There's no way to recoup that cost. So the SR6 report, the EMS portion, our board actually looked at, and there were 5 recommendations that they decided were our priority. And again, this was before COVID, and they all had to do with reimbursements and staffing. So since the SR6 report, there have been other workforce studies. The American Ambulance Association recently sent a letter to Congress, and they talked about the survey that they did involving 20,000 employees working at 258 EMS organizations, and that's across the country. Their turnover among paramedics and EMTs ranges from 20 to 30% annually. That means 100% of the workforce is going to turn over in a 4-year period. I mean, that's, where are they coming from? We're not able to recruit, we're not able to retain. So the pandemic has exacerbated this shortage. EMS personnel are exposed to COVID. They have to be quarantined. If they get COVID, then they're not able to run. They have to backfill with other staff. Where's this staff coming from? Because they're not out there. So part of the American Ambulance Association's letter also talked about funding. And we're actually changing the terminology a little bit from reimbursement to funding, because it's not just reimbursement. They need more than just paid for when they transport somebody. There's a cost to readiness. Municipalities can actually help them. And I know Jerry's going to talk about a particular piece of legislation, Senate Bill 698. So I won't go into that. Recently, sorry, I have like all my little tabs and everything as I go through, being the paper person that I am. Texas recently, they have been looking at ways to increase their workforce. They did a survey and they found 27% of the licensed EMS professionals in Texas submitted a PCR in the first 8 months of 2021. 43% submitted a PCR in 2020, 45% submitted a PCR in 2019. And this is from the Texas EMS Alliance. So that means 45% in 2019, 27% in 2021. So Texas is also experiencing issues. They recently, we just found out 2 days ago that they actually got a $20 million allocated towards recruitment and education for EMS professionals. So congratulations to Texas. So what is Pennsylvania doing? We are getting ready to release a workforce study, if you will, a brief 10-question questionnaire, so we can find out exactly how many professionals or providers are missing from EMS agencies and exactly what that is going to, how it's going to extrapolate across the state. So that's very important. So for all the EMS agencies that are on Zoom or face-to-face, when you see this come out, if you could please fill in the survey. We're trying to keep it very brief. But when we go and we talk to the legislature and we tell them that we are short-staffed, it is very important that we have this specific data. Dylan understands when it comes to data how important it is, because I use the data that Dylan gives us all the time. So there are a couple of pieces of legislation that have kind of risen to the forefront of what we really need at this particular moment. And I'm going to start with House Bill 1293. This is not a new concept. This is direct pay legislation. And what it would do, it would actually allow the commercial, or force the commercial insurers to pay the EMS agency directly. This is not new. This has been introduced I've been with the association for 15 years, and I know that this has been an issue since I've been around. And I know it was before then as well. So in 2014, I believe, Act 84 would have allowed EMS agencies to become it would allow agencies to accept assignments, so they would be able to receive the check directly. However, there were caveats to that. They were not allowed to balance bill the patients, and I'll get into a little bit with balance billing, but it was an issue. And at first, there was only 21 providers or EMS agencies that did opt to accept assignment, and now there are 0. And Dylan, I'm just going to confirm with you that that is correct. All right, that's what I thought. So what we have been told by our members is that the in-network rate is not enough to sustain financial viability of the EMS agency. So they have opted to not accept the in-network rate and decided to take their chances. One of the other issues as well is that EMS agencies cannot collect a copay or a deductible at the time of service, because the last thing you want them to do is say, I'm sorry, Mr. Smith, I know you're having a heart attack, but I need to see your insurance card and I need to collect your deductible or your copay. So then after the fact, trying to collect that money is not an easy task. So House Bill 1293 would force the commercial insurers to pay the EMS agency directly, and there are no caveats to that. It actually removes the language that was part of Act 84, and they would be allowed to balance bill the patient. We have had a call to action since June, asking our members to reach out to their legislators and tell them they are totally different from other healthcare providers. EMS has to respond. There's a duty to respond. They have to be in service 24/7, and there's some other caveats to that. But we're not like other entities that provide medical services, because like I mentioned, you can't collect the copay at the time of service. EMS is different from other traditional healthcare models because we cannot collect the payment and we have that duty to respond. So those were kind of the items that we wanted to hit home with the House members. I actually reached out to the AAP members who are in House Insurance Committee members' constituents. So Representative Tina Pickett actually went out to visit Greater Valley EMS. So we've been trying to do a boots on the ground efforts to get them to reach out to their legislators. And so now this piece of legislation is in the House Insurance Committee. And so we will be pushing to get Representative Pickett to bring a vote to the committee to have a hearing so that they can hear about the issues. The other legislation that would have provided direct pay in previous legislative sessions actually was referred to the Senate or the House Veterans Affairs and Emergency Preparedness Committee, and the insurance lobby had told us that they did not believe that that was where this legislation needed to go. They believed that it needed to go to the House Insurance Committee, which is where it is now. So getting that out of the way, we need to get this piece of legislation brought out of committee onto the House floor, over to the Senate, and then to the governor to have him sign it and not veto it. Another bill is House Bill 743. During COVID, there were COVID relief packages that were offered. For instance, the hazard pay grant. I know everybody heard how first responders were on the front line and they were providing all these services. We didn't get any relief, none. In the hazard pay grants, there was not one EMS agency that received any grants. Brink Security did, but not any EMS agencies. And I think that that's ludicrous. House Bill 743 would provide some COVID relief. It would provide grants up to $150,000, and the eligible applicants had to have experienced a reduction in gross receipts of 25% or more for the period of March 31st, 2020 to December 31st, 2020. And right now, this is in the House Veterans Affairs and Emergency Preparedness Committee since March the 3rd. Another bill on the Senate side is Senate Bill 526, which would provide for a medical assistance increase. EMS has only received 2 increases in the medical assistance reimbursement in 40 years. 40, not 14, but 40, 40 years. So we recently, what this bill would do is it would take the EMS portion of the fire and EMS grants, and it would actually put it into a medical assistance reimbursement, and then we would get the federal match. Unfortunately, we had a meeting with Senator Pittman, who is the prime sponsor, and representatives from DHS, as well as the fire commissioner and other legislative staff. And the staff from DHS has said that they would not be able to accomplish what this bill wants to accomplish in the way that the bill is written. They said that CMS has caught on to their scheme of trying to get additional reimbursements to EMS providers. And I say that because it's a little offensive when we've only gotten 2 increases in the last 40 years. They said that we had gotten a significant increase recently, which you go from $120 to $180 for a BLS reimbursement. I don't think that's a significant increase, but that's what they said. They claim that they have language at the governor's office that would accomplish what we hope to accomplish. So I have not seen that language yet. In the short term, we were looking at this as a short-term fix. From a long-term perspective, we are actually looking at a medical assistance provider assessment. And there are other states that have done this. It's called GEMT, it's called provider assessment, where and I know the nursing homes actually have this, and I'm not real familiar with this yet. We have a lot of education to do in 2022, because in order to institute this, we have to get the majority of EMS agencies to agree to do this. EMS agencies would pay an assessment based on their total universe of claims, and then in turn, they would get a reimbursement increase, a reimbursement bump when they file a reimbursement claim. So this is the long-term strategy. It requires legislative changes, which we have experienced some frustration when it comes to reimbursement changes, because most of our issues are related to money or staffing, and they are a heavy lift because we do go up against the insurance lobby. We go up against the Department of Human Services telling us, no, we can't do that. So we are trying to be loud in our calls to action. The last bill I'm going to talk about is Senate Bill 861, which was just introduced and referred to the Senate Veterans Affairs and Emergency Preparedness Committee on September the 14th, is the Interstate Compact. And so there are 21 states that participate with the EMS Compact, and there are over 200 interstate compacts. And for instance, the driver's license, that's a compact. So this would allow EMS providers coming in from other states not to have to experience a delay in order to provide service and become an employee or a volunteer with an EMS agency. So that is actually relatively new. I'm going to talk about a couple of other things. I don't want to take up too much time because there's a lot that we're monitoring. As Steve and Christy talked about, vaccine mandates, we are monitoring that. We're actually looking at what they're doing nationwide with nursing homes, with others. We're just kind of, for situational awareness, what's going on universally. And I want to thank Paige Wolfberg and Wirth for allowing me to share their information that they put out to their clients. I actually put that out to our members, and I do thank you for that. One of the issues that has come up recently is hospital diversions and the wait times to transfer the care of a patient in hospitals. And I know that there's a nursing shortage. I had a conversation with the reporter from Penn Live yesterday where he was asking me about the hospital diversions, and then I ended up getting into the EMS workforce shortage and our call to action on House Bill 1293 and how funding the EMS system is so important. Yesterday, there was a information that I was able to supply to our members on the supply challenges that EMS experienced during COVID. The Senate, and this is at the national level, the Senate Homeland Security and Government Affairs request was to ask EMS to provide information if there was price gouging. And we actually did experience some price gouging at the beginning of the COVID pandemic. Balance billing, not only do we monitor legislation that we support, there's also legislation that we try to prevent. And prime example of this is House Bill 1862 from the last legislative session, which would have put a prohibition on balance billing across the board for everybody. And so EMS was really strong and on the forefront of saying, you can't do this. This is going to kill us. So thank you to all the members and non-members that actually did participate with that, because we were able to stop that. One of the other items is payment for treat no transport. We were successful in getting a law passed, Act 103, that would provide payment for treat no transport. What we're experiencing now is that insurance agencies are paying $75 for payment for treat no transport, and some are paying more than that. So it's not consistent. So we're trying to get a consistent payment message or payment method. And then we've actually met with the insurance department, and the insurance department has basically told us that they can't help us. They sent us on a wild goose chase for about a year. And then there's bills all the time. There's probably over 100 bills that we're looking at, not only from an EMS perspective, but also from a business perspective. The Ambulance Association actually looks at EMS from a business perspective. So if it's a workers' comp issue, it's insurance, there's a lot of different things, any kind of employment issues. And I think I'm going to stop there because I don't want to monopolize the whole time. But I do thank you for allowing me to provide this information. And if anybody has any questions after we're done, I am happy to answer them.
Thank you, Heather. We do have about 20 minutes left in this panel. So did you guys do the eeny, meeny, miny, mo? Jerry, are you next?
Okay.
All right. Thank you.
Thank you very much, Doug. And Heather did an excellent job explaining the current state of the situation legislatively. Again, I wish I had better news to talk about also in regards to Senate Bill 698. A little bit of historical perspective, and 698 came out of SR 6 as one of the initiatives that would assist in regionalization or reorganization, mergers, consolidations, and things like that. That came out of that point. However, that point in SR 6, however, the intent of creating countywide public safety authorities was to assist and including a new funding stream for emergency services organizations. It would amend the Municipal Authorities Act, in Pennsylvania to specifically allow for EMS and fire at the countywide level, a municipal authority to be established, okay? And the intent of that, and again, there was some misunderstanding of, oh, we're going to have a countywide ambulance service. We're going to have a countywide fire service. That was not the intent when that was developed. It was to organize better at the administrative level. It was to work to come up with another funding stream. And Heather talked very well about the things that are happening legislatively at the state level to try to increase funding for EMS. And this was the first initiative at the county or local level to attempt to deal with this. Because many of you are EMS leaders, EMS managers that deal with municipalities on a regular basis, okay? Municipalities have a choice. They could either, again, when you look at the local government is responsible to ensure emergency medical services and fire services and fund at the level that they deem necessary. And if you have a good relationship with your municipality and, they kick some funds your way for operations, that's great. But in many places across Pennsylvania, that funding is not happening, or it's in a small amount. I was in an area of Pennsylvania recently where, those of you that run ambulance services on a regular basis, how long, how long $5,000 will go. Okay, and that doesn't go a lot. So the challenge that we are faced with, we developed with a collaborative effort, and I want to, again, started with Senator Carney in Delaware County, Senator Baker in the northeastern Pennsylvania. We had, no less than 6 meetings with a variety of stakeholders. When legislation is developed, the best way to move forward is a, bipartisan method where everyone is involved. The stakeholders are involved early. We had, over the last 2 years, we had many roundtable discussions via Zoom with key members and staff members from the Senate, all of the statewide organizations. You have the emergency services organizations, again, AAP, our organization, Firemen's Association, the Pennsylvania Professional Firefighters Association, and then you have the local government associations. The local government associations are the townships, the boroughs, Pennsylvania Municipal League, and then you have the state agencies that are involved, the Department of Health, the Fire Commissioner's Office, and there's debate, okay? And there's debate in how this will work, and then somebody brings up a concern, and that original legislation, a sentence is added to it that deals with that person's concern. And then there's another draft that comes out, and eventually, it gets to a point where there's a hearing, okay? And the hearing is, and again, let me step back one bit. The associations and organizations are supposed to kind of communicate to everyone on what's going on, communicate to, sending emails out, speaking about it. What is this all about? And I do want to let all of you know, and I want you to please get a chance to go to Senator Stefano's webpage, okay, and watch the video from the October 12th hearing that was in Connellsville, Pennsylvania, okay? Pretty much, I'd say like a 3-hour video, but if you want to know where this current legislative initiative stands on countywide public safety authorities, all you need to do is watch that video, because that video clearly will identify those that are for it and those that are against it, okay? And it brings me back to the point is we have challenges in Pennsylvania. You all know, as EMS managers, EMS leaders, the sustainability of your service is in jeopardy. The sustainability in the rural communities, in the suburban communities, in the urban communities. And funding is a major part of keeping a system solid, a major part. May you be private, nonprofit, or municipal based. This legislation would have given an option to do that. There is governance and things that are involved in it, but there are people that are opposed to it, okay? There are people that are for it. And those that have been involved in the legislative making process know that it is sometimes difficult to do dramatic changes in Pennsylvania, okay? Especially when it comes to establishing what some people think is another bureaucracy that will tax the citizens and have a questionable outcome. So I just want to be honest in discussing it, because the future of your service, the future of providing ambulance service is on all of us to, number one, continue to advocate at the local level, okay? Continue to develop those relationships with borough officials, township officials. Continue to advocate at the local level with your state representative and senator, okay? And get involved in the statewide organizations, get involved in AAP, get involved in our organization, because only us and continuing to communicate. Heather spoke very well about the 15 years or the 20 years of struggling for the change in legislation for direct pay, okay? We don't want to go another 15 years talking about a countywide public safety authority. Okay, we know the positive things that can come out of that, and we strongly feel that it is a good thing, meaning our organization and several others. And we've been working with those other organizations who are opposed to it to kind of talk through those things. But again, when we talk about leadership in Pennsylvania and organizations that have a growth mindset, and a fixed mindset. And that fixed mindset is, this is the way we've always done it. This is the way we're going to do it. And I don't think the survivability of our services are going to be very good if we continue to have that fixed mindset. We have to have a growth mindset and continue to move forward to the future. Thank you very much.
Jerry, thank you. Before I let you go from the podium, real quick, you talked a little bit about the opposition to the municipal authority law, and you mentioned, new taxing entities and that kind of thing. But I was wondering, I think it's important to understand the basis of opposition, because we talk about public policy. There are competing interests. It doesn't mean the other side's evil. It doesn't mean they're wrong or bad. But can you just expand on that a little bit more? Because I think it's important to understand what the basis of the objections to something like that. And the postscript to my question is that it's no secret that Pennsylvania is a very fragmented local government structure when you particularly compare it to neighboring states that do centralize things in counties. Can you talk about that in light of that issue?
Absolutely.
Thank you.
When you look at Pennsylvania's system of local government, you have to go back to the demographics in Pennsylvania, and the census just came out. And when you look at the census in Pennsylvania, it truly has turned into communities of haves and have-nots. Okay. When you look at the rapid graying and declining of populations in certain counties, and the increase in population in other counties, okay, that fundamental community demographic, that change goes directly back to the governance in that community, okay? And that governance in that community, local elected officials have a lot of power to raise taxes, keep the services at a certain level, decrease services. And when you're elected to a local level office, you listen to your constituency, you listen to the people. And maybe that local level organization, there's people that maybe a plant closed and there's unemployment in that community. Or again, there's more seniors living in that community. And if we implement this fire tax and implement this EMS tax, they're going to have to pay an extra X amount of dollars a month or a year. And the challenge that we face, again, those organizations are representing their constituency, and twisting that back to our role as EMS, and never give up in advocating and never give up in talking about that. Nobody wants to, I'll be honest with you, none of us want to raise taxes, but there's clear examples from other states of solid EMS systems, solid funding structures that are at the county level, the multiple municipal regional levels that can make a difference. But again, it is a fragmented system. We have municipalities that are contributing to EMS, and one line over, you're still required to respond to that call. And that organization, that local government is not providing any funding. And, all of the concept of the cost of readiness and those type of things continues to be a challenge. So.
Sorry. Thank you, Jerry. So people don't want to pay taxes, of course, but until they call 911 and say, why did it take the ambulance more than 8 minutes to get here? But just in the interest of time, I'll just put a bow on that. So thank you, Jerry. Last but certainly not least, Dylan Ferguson from the Bureau of EMS from the Department of Health.
And don't worry, I'll wrap it up quick for you.
Oh, no,
Keep on
please.
schedule.
Take your time. We'll take it out of our hide,
Oh,
not
fair
out of
enough.
yours
So-
if you need more time.
Good morning, everyone. One of the things that I'm going to try to do right now is I'm going to try to take some of Heather's remarks, and I'm going to try to take Jerry's remarks, and I'm going to try to bring it all together with a statewide perspective and put a nice, neat little bow on top. We talked, when Heather spoke a lot about the fact that, there have been 2 Medicaid increases over the course of the last 40 years. There have been long-term issues with trying to secure direct pay from third-party insurers. There have been instances where, we're concerned about having a debate on public safety authorities, over the course of the next 15, 20 years. And we look at the evolution from SR 60 to SR 6. And the fact of the matter is that for SR 6, for the most part, we could have taken SR 60, just dropped off the zero, changed the date, reissued the same report, and probably saved all of us a whole bunch of time and probably saved the taxpayers a little bit of money. But the reason why I summarize all of those is the fact that here within the Commonwealth, our emergency services, in the way that they are funded, the way that they are supported, and the way that they are ran administratively, has not significantly changed over the course of the last 30 to 40 years. Rather, we are historically trapped in what I will refer to as legacy processes. And those legacy processes are extremely difficult to change. The lawyers in the room know that the wheels of government turn slow. And that is something that, you know, in your area of expertise of the law, you are aware that, you know, those changes are slow. Oftentimes they are deliberate. And to kind of punctuate Doug's point, it is usually driven by various communities of interest trying to push their own points and their own agenda. Whereas when we look at emergency services, whether that be fire, EMS, of course, which I'm partial to, or law enforcement, operationally, those services and the way that those services are provided operationally has significantly changed over the course of the last 30 to 40 years. Whereas emergency medical services, when it was really first formed with the white paper from NHTSA, essentially EMS at that time was, let's throw them in the back of the hearse and drive as fast as we can to the hospital. Whereas today we have paramedics who work in advanced life support ambulances that carry anywhere from 60 to 70 different medications that can save your life, can perform advanced medical procedures. We have EMTs now that can defibrillate patients. It used to be when defibrillation first came to the field, it was all manual defibrillation. There were like 2 places that maybe had them, and you had to take a 120-hour class just to be able to use those paddles. But now, every basic life support ambulance in the Commonwealth of Pennsylvania and mostly across the country have AEDs in them. So ultimately, this is the construct which we find ourselves. We find ourselves that operationally we have grown, and administratively and from a funding aspect, you know, we have significantly lagged behind. And it really takes us to this dichotomy of human nature, where we all want Cadillac level services. We all want the Cadillac. But the fact of the matter is, and Doug kind of summarized Jerry's point pretty well, that, you know, no one wants to see their taxes increased. So as a result, we want the Cadillac, but we want to pay for the Yugo. And ultimately, those are the fundamental issues that we're dealing with. So I wanted to first off just kind of summarize all of that and bring that together. A couple of things that I just want to discuss briefly from a regulatory perspective, being the state's lead EMS regulator. COVID-19 has certainly posed some challenges to the department, to the administration, to emergency medical services, hospitals, emergency departments, you name it. Pretty much everybody's life has been impacted by this. And this is an interesting, this is kind of an interesting topic, and I'm going to try to bridge this to the lawyers and also to the EMS providers in the room, where, you know, we have, throughout COVID, we have gone through several different iterations of statutory and regulatory suspensions, in addition to dealing with any number of constitutional issues related to emergency powers of the executive. So back in April of 2020, I issued, under the authority of the disaster emergency through the governor's office, a number of staffing exceptions to Pennsylvania's ambulances at the BLS, intermediate advanced life support, and advanced life support levels. And essentially what we did was that we changed the staffing complement. And probably the biggest one that has been an impact was to allow basic life support ambulances to operate with a single emergency medical technician and then just someone to drive the ambulance. Whereas in the past, basic life support ambulances were required to have an emergency medical technician and an emergency medical responder, which is the lowest level of recognized pre-hospital care that we have in the Commonwealth. And we made some other changes at some of the other levels, but they weren't as drastic. And fortunately, at the time when that regulatory exception was first implemented back in April of 2020, there wasn't necessarily an immediate need for it in most sections of the Commonwealth. Whereas New York State and some of our neighboring states saw absolutely crushing EMS transport volume in the initial phases of the pandemic, Pennsylvania actually saw the opposite. In that first wave of that April, May, and June, EMS transport volume, of which EMS derives all of its revenue, fell nearly 25% across the Commonwealth. So I want you to, there were a lot of businesses in the, retail and restaurants that were also struggling, and they were seeing, revenues significantly decreasing or, cut to zero. But emergency medical services was also caught up in that. So, we didn't have those crushing volumes to begin with. We have kind of rebounded back to our normal baseline as to what constitutes, I guess, as normal of an EMS system as you can. But the fact of the matter is that there are challenges that remain in that kind of that deployment paradigm. I know Heather kind of alluded to hospital diversions and increased wait times, and those are symptoms of a healthcare system that is stressed overall. Not all stress necessarily comes from sheer volume. Some of it does, because from that first wave, there was a lot of healthcare that was deferred. We call it elective procedures, or, people who were just afraid to go to the hospital. Eventually, all of that care has to be provided at some point. And in some portions of the Commonwealth, that's what we're seeing. We're seeing this log jam of old issues that need to be taken care of along with today's emergencies. So kind of transitioning back to some of the other regulatory and statutory exceptions that we put into place. One of the other ones that we put into place that resulted in a statutory suspension was to allow individuals who held out-of-state EMS credentials or were credentialed by the National Registry of Emergency Medical Technicians to be able to operate within the Commonwealth solely on the basis of that credential. And then the last one was from an agency licensure perspective, was to allow entities that were solely licensed out of state to be able to come into the Commonwealth and operate on the basis of the license from their home state. And that was all done on the basis of trying to ensure an adequate workforce, in the event that we would see increased and those crushing volumes. And ultimately, this has been a very unique process, because the only way that most of these things that I have mentioned would have been possible would have been to suspend a regulatory statute. And for what I'll call the legal eagles in the room, you are likely aware that Title 35 and the provisions that allow a governor to declare a disaster emergency allow them to suspend a regulatory statute. So for a while, that was the legal authority in which we were operating under. And then cue a constitutional issue. Constitutional amendment passed in which kind of changed that entire statutory and regulatory landscape. And ultimately, the General Assembly on two separate occasions passed legislation which allowed state agencies, boards, and commissions to be able to continue at their discretion statutory and regulatory suspensions which had been in place on the day that the initial disaster emergency terminated. So that is from where we're currently operating. There are any number of statutory and regulatory exceptions from across numerous Commonwealth agencies that remain in place. And I believe that the most recent law that passed actually extends those through March 31st of 2022. The last issue I'm going to talk about, because, you know, my two other co-presenters have talked about funding issues, and I also have a funding issue to kind of highlight for everyone, but mine doesn't rely or relate to individual EMS agencies or individual EMS providers. Rather, mine focuses on the EMS system as a whole. So in Pennsylvania, we have something called the Emergency Medical Services Operating Fund. This fund is basically used to support our regional system of EMS system support and development. And this system is carried out by 14 different organizations. We have 13 regional EMS councils, which the EMS providers in the room are familiar with. But they are the Department of Health's eyes and ears on the ground, and they are our frontline interface with most of the EMS agencies in the Commonwealth. And then the 14th member is the Pennsylvania Emergency Health Services Council, which serves as the state advisory board and the state advisory body to the Department of Health Bureau of EMS. And so we utilize this MSOF funding that we call it, to fund these organizations for them to be able to carry out their work plans and to support the EMS system as a whole, to help carry out inspections, to help certify individuals, and to help license organizations. Ultimately, this MSOF fund is created, and this funding is generated by a tack-on fee to moving violations within the Commonwealth, including an additional fee for accelerated rehabilitation, or ARD, in cases of DUI. So pre-COVID, there was a passage of Act 93 of 2020. Act 93 of 2020 did something that was very positive. It created the first raise for the MSOF fund since 1985. We want to again talk about legacy processes. This is another perfect example of that. I don't know, you know, if we take a look at inflation and some of the pain that has been caused recently, now I want you to imagine that extrapolated out, you know, since 1985. And that's been a struggle. And ultimately, it's my job to budget and allocate that funding based on the appropriation from the General Assembly. But Act 93 doubled that moving violation, and it doubled that fee for accelerated rehabilitation. Moving violations went from 10 to 20, ARD went from 25 to 50. And initially we were all like, this is great. This is going to be fantastic. We're going to finally be able to start to move the system forward. Well, then this little thing called COVID showed up. And for lack of a better term, or lack of a better way to explain it, revenues from traffic citations absolutely collapsed. Those of you who were on the road at the beginning of the pandemic, you were like, hey, where is everybody? Well, everybody was home. Nobody was out traveling. And this persisted. And this is actually a trend that still persists, not necessarily because of traffic volume, but for other reasons. You know, we are not seeing the revenue that we expected to see with the doubling of the fee. There are also some questions of whether or not, from a public policy perspective, whether or not that is the best type of funding source, to essentially have to rely on someone to violate a traffic law in order to sustain an essential service. And I think as we see more of an involvement and discussion of social justice and things of that nature, I think that those types of fees and those types of punitive actions are likely, are really likely to be, called into question. Ultimately, when the EMS system was first started, the funding mechanism of traffic citations and DUI ARD made total sense. And the reason for that was EMS fundamentally started as a trauma system. We were largely created to respond to traffic accidents. That's one of the reasons why EMS, the Office of EMS at the federal level, continues to live under NHTSA. But really EMS has evolved to so much more than trauma and throw them in the back of an ambulance, and rather really now is a fully comprehensive mobile emergency department. And as we, see more and more municipalities, for example, the city of Philadelphia announced the other day that, there was going to be a de-emphasizing of traffic citations and making traffic stops for, minor issues. And when I look at that, I mean, I look at it from a lot of different lenses, but through this funding lens right now, there is certainly a possibility that, that could have an impact to that emergency medical services operating fund. So those are some of the overarching issues that we're dealing with that. Complicating that, and this will be my last point, complicating kind of those MSOF allocations is a very good thing, but also a very challenging thing considering everything that we've kind of just discussed with the revenues. There was a second part of that law, and that law specifically stated that now 30% of that emergency medical services operating fund must be solely used to fund EMS training in underserved rural areas of Pennsylvania. And an additional 10% were specifically earmarked to purchase medical equipment for ambulances. I don't think that anyone would argue that those are important functions that need to be carried out. The problem, though, is adding additional policy objectives and policy earmarks at a time when the fund is actually decreasing and didn't generate the expected revenue does create a problem from an administrative aspect of trying to accomplish all of the wants on sometimes an unreliable funding source. So that's kind of just a highlight and an overview of different issues going on within the department, the Bureau, and the system. And Doug, I'll turn it back over to you.
Thanks, Dylan. Thank you very much. Really quickly, as Steve comes down and gets reset for the next discussion, one benefit of being a dinosaur, Dylan, is that having been around, and John and Ed, few here in the room were here at the same time. In 1985, when the EMS Operating Fund was adopted as part of the EMS Act of 1985, the intent was that that fund would supplement funding for EMS. And it came to pass that the legislature said, oh, well, they've got this dedicated funding source, so we're going to zero out the line item for EMS in the state budget. I feel like we were double crossed, quite honestly, in 1985, because I think at the time the line item was $3 or $5 million, if anybody remembers. And then the legislature said, oh, well, here's, we can take that $3 or $5 million and put it somewhere else because EMS now has this revenue from these moving violations. It really was a legislative double cross, to be quite honest with you, to call it what it was. So, the intent of that was never to be the administrative operating revenue for the EMS system. And I think over time, that crime sort of, to call it that the line item for EMS administrative operations being zeroed out because of that dedicated fund has been lost to history. And I think one way that the legislature could remedy that would be to restore the line item for EMS administration and let the operating fund do those other things. But that is, again, wholly political. The only other thing I want to just highlight from that last session was something that Jerry said, which is that the 6 most dangerous words in the English language are "we've always done it this way." And, EMS has been plagued by that phrase. And, the challenge to think anew about this and to separate funding not only from transports, which Heather talked about, that we're limited in that, but that Dylan talked about funding our system through a discretionary citation that law enforcement may or may not issue is not reliable or sustainable. So just what an outstanding discussion. So thank you, Dylan. Thank you, Heather. And thank you, Jerry. Okay, so next, Brian, we are going to go into one more slide deck here,
Last slide deck.
which he'll bring up on the screen here. But as he's doing that, I'll queue up the topic. Steve and I are going to talk about. We were going to talk about surprise billing, And we decided, a consensus of the planners here, that this was really more timely of a topic, not to give short shrift to surprise billing, because Heather talked about that. And we are seeing activity on the federal level, the Federal No Surprises Act, which prohibits balance billing by air ambulances. The tea leaf reading is that that will be extended to ground ambulances in the coming couple of legislative sessions federally. And we'll have to keep an eye on that, because that is a very significant potential issue in terms of funding and sustainability. And I'll just make my last political comment on that, and that is that, you know, there was a little bit of discussion in Heather's talk about the tug of war between the insurance industry and the provider community, which is not new with direct payment. But, you know, frankly, the insurance industry has done a better job of labeling the problem surprise billing, like any consumer is surprised that a healthcare provider bills for what they do. It's really been surprise coverage that those insurers have not necessarily covered the charges of the providers, but they've, you know, like I said, they're better funded. They've done a pretty good job of naming that problem, which is why Congress's action has been directed toward reining in the activity of billing by providers. But just not to overlook that topic of surprise billing or balance billing. But with that said, Steve is going to kick off our final topic here, which is EMS provider criminal liability and the cautionary tale of the Elijah McClain case. And then I will jump in again, but Steve, go
Okay,
ahead.
Great, cool. We're just going to tag team this a bit and get the discussion going. We changed this subject because it's such a hot issue, and it sort of stunned us when we saw the criminal indictment of 2 paramedics for the care they provided. And that's what we're dealing with the cautionary tale of the Elijah McClain case. And there's a lot of lessons to be learned from this that we could all take home, because all of us who've worked in the field for many years, we know there's a problem in the field between the relationship between police and EMS in terms of that transition of someone in custody or someone who's being detained or confined. And we have to work on that, because we don't want to have these kinds of situations occur. Well, unfortunately, Elijah McClain was a 23-year-old black male. He's walking home from a store and basically minding his own business, but he had a bit of a mask around his face because he suffered from a condition that causes him to get very cold very easily. So he's trying to stay warm in Aurora, Colorado. And somebody called and said, there's a suspicious person. You know, you guys better get down here. So the police arrived, and then it went sour from there. But we're going to talk about why this case is so unusual and just talk about a few of the facts, and then talk about the investigative report and some of the findings that were made there, and then what we can do to help hopefully avoid this kind of litigation or criminal indictments in your own agency. Well, we've seen criminal acts against EMS providers before. That's not new, but it's the more traditional things like vehicular homicide, sexual assault of a patient in the back of the ambulance, assault and battery of a patient at the scene. Those are the kinds of things we typically have seen. We've never seen anything like this, where there's been a criminal indictment concerning the care given by paramedics. But that happened on August 27th, where a Colorado State grand jury indicted 3 police officers and 2 paramedics who responded to the complaint concerning Elijah McClain, who ultimately died as a result of that interaction. So you can take a look at the indictment. That's in the handout materials that you have. And keep in mind, this is an indictment. There's no finding of guilt here, okay? A lot has to happen. There's no trial yet, so we haven't had that trial by a jury of your peers yet, and who knows if it'll get to that point. But certainly it raises the specter of, gee, can this happen to us, okay, is really what it comes down to. So as I mentioned, he's walking home, and immediately the police took physical control of Mr. McClain. And one officer told other officers, "Oh, you reached for your gun." Well, in reality, after the investigation ensued, that didn't happen, according to other police officers there. They applied a carotid artery control hold on him, and other restraint measures were used. And he was a tall, thin gentleman. And he then vomited into his face mask, but he was unable to remove his mask or clear his airway, and then lost consciousness. So at this point, they have him down on the ground. They got these various maneuvers to control him, but Now he's got an airway problem. He loses consciousness, and that's when the police officers decide to call Aurora Fire Rescue. And two of the paramedics arriving from Aurora Fire Rescue find him, and they saw that he was restrained and in handcuffs, and EMS supposedly was informed that this carotid control hold had been applied. He previously lost consciousness, but they denied any knowledge of that maneuver. But the indictment alleges that the two medics pretty much stood by Mr. McClain here and really didn't do anything. They didn't speak to him. They didn't ask him questions. They didn't assess his condition. And then, they observed McClain being forcibly pushed down by the police. And one medic says to the police, "We'll just leave him there until the ambulance gets here, and we'll just put him down on the gurney." Okay. Again, no assessment of his vital signs or condition or airway or any of that. And of course, ketamine is a drug that's being used to deal with patients in conditions like excited delirium, to control them, to sedate them, if you will. And it's a common drug that's used in EMS today. It's a very potent drug. It's very effective, okay? But it could have been any sedative, could have been other medications that could have been used. But the bottom line is they overestimated his weight to be around 200 pounds. In reality, he was 143 pounds. And essentially, they gave him too much ketamine, all right? But the autopsy report didn't say specifically that that's what caused the death of Mr. McClain. But that was, certainly what happened here in terms of the facts of the case. So after about 2 minutes after the ketamine, they placed him on the gurney. He was unconscious, visible vomit. They get him in the ambulance, no pulse or respirations, and he was ultimately CPR administered, resuscitated, but declared brain dead 3 days later. So here's the charges: manslaughter, criminally negligent homicide against the paramedics, assault in the third and second degree, crime of violence, unlawfully causing serious bodily injury, unlawfully using a deadly weapon. In this case, the indictment is that the deadly weapon was ketamine, and that basically they administered a drug inconsistent with standard protocols. So also what's going on here is that they're saying, well, look, if you don't follow the protocol, that's a criminal act. These protocols are the standard, but you didn't follow that, therefore you committed a crime. Well, that's not the usual way it works. Usually we talk about negligence and mistakes, because we all know mistakes happen in healthcare. If you look at any number of studies, the fourth leading cause of death in America is medical errors, okay? So it happens, okay? So they describe this as an unlawful protocol deviation. We've never heard of anything like that before. And they certainly did screw up here, okay? They didn't provide a reasonable estimate of his weight. They didn't assess his condition. They pretty much stood back and really let the police take charge, and the paramedics sort of went along with the show. At least that's what was revealed in the investigative report. And that we're going to talk about. But failing to properly monitor him, they knew that these potential complications would occur. It was like inevitable that this was going to happen to him. And then also alleging that there was no consent to administer the medication. So when we look at, civil versus criminal conduct, and we talked about that a little bit this morning, I mean, ordinary negligence, typical in the healthcare setting and hospitals, doctors, nurses are held to that standard of the reasonable and prudent nurse or physician. What would they do in this similar situation, okay? An unintentional mistake is really what negligence is. But we're fortunate at EMS because of the unique nature of what we do, and under emergency conditions, worst possible conditions at times, outside the four walls of a controlled environment of the hospital, to prove negligence against us, in most states, that has to be more than a mistake. It has to be indifference or reckless disregard, okay? Yeah, a little more serious than a mistake, but then beyond that is criminal negligence, willfully and purposely acting recklessly with disregard to obvious risks to human life. Sort of like, drinking Clorox here, knowing what's going to happen. Yeah, that's criminal negligence. You give somebody that. But the investigative report ensued. It's 157 pages. There he is. I decided to print it off, but it's chock full of, a lot of information that we certainly encourage everybody to take a look at that. But basically, the gist of it was a lack of accountability, lack of a proper procedure for handing off the person restrained to EMS, and really no proper steps in place or policies to deal with these kinds of situations. And I think most of us in this room would acknowledge that we all have had this problem, okay, over the years. And there's a tendency for us to just go along and become sort of like the agents of law enforcement rather than being the agents of the patient that we really are. And that's what was really pointed out in this complaint. So you want to pick it up and go through some of this too, or do you just want me to keep firing on?
Great job.
All right, because we didn't even talk about how we're going to do this. So, so here was the concerns expressed in this report. Now, when you listen to these, you're thinking back, sounds like a problem we might have. Delays in clear transfer of control from police to EMS, lack of communication, information loss, delay and incomplete assessment. Failure to obtain appropriate equipment. They didn't bring the equipment out, okay? And that's another thing we're seeing recently in some of these cases, going all the way back to Eric Garner in New York City. Remember the I Can't Breathe case, okay? Well, in that case, hospital-based paramedics showed up. They didn't even bring their equipment up to the side. And allegedly, one of the paramedics said, had her hands in her pockets and said, "Is he ready for the bus yet?" Referring to, Mr. Gardner, who's now prone, gasping for his last breaths of life. So not bringing our tools of the trade with us, inaccurate estimation of the patient's weight, and the role of cognitive errors in medical decision-making. What are those cognitive errors? Our inherent biases, unconscious biases. We get a call at a mini mart at 4 a.m. for a person sick. What do we automatically think? Oh, they're probably intoxicated. That's the first thing, because that's our experiences. We have a lot of those negative experiences that are ingrained in our mind. And that's what happens in a lot of these cases. And there's a lot of good information in this report. It really comes down to, this whole legal versus moral duty that Doug alluded to this morning and spoke about. Yeah, do we have a legal duty or a moral duty? Well, I think we sort of have both in these cases, because if we're responding, we have a duty to act. And that duty to act, you can't just sit back and say, "Oh, I have no duty because I haven't touched the patient yet." Well, some people actually use that as an excuse for not accessing the patient. That's wrong. And I think in negligence cases, we're going to find that courts are going to find some liability in these cases with you standing back. So we got a duty to take proper action to prevent harm to the patient. That's our responsibility. We're the medical experts when we get to these scenes. The police are not, okay? So there has to be some deference given to us, and we have to actually do our job to try to access the patient. And that's part of that legal duty to act in our view. So we got to be accountable for our actions and our inactions. We're seeing more and more cases today where EMS practitioners are not always fulfilling their responsibilities professionally. They're not bringing the equipment to the side of the patient, or they're short shrifting a patient. Look, it's stressful out there. We know that, and we're under great pressure today, but that doesn't mean we treat the patient any less than we would want to be treated, or we would want our loved ones to be treated. So in our view, it really comes down to this. If you follow these rules here, you generally can't go wrong, especially with interacting with others. And that is, we got to recognize a duty to question ourselves. That a true professional recognizes when they make a mistake, or they don't know something and they ask for help, or they get their partner involved and say, "Hey, help me out here. I'm having trouble with this particular skill," or whatever. We have a duty to question each other. And that's part of the issue here, is there's a lot of group dynamics that are going on here. When you're in a group, you're more likely to go along with the rest of the group and not do anything, not question your partner if your partner is being abusive to a patient. Or, in the George Floyd case, there was more than one police officer there, only one had his knee on Mr. Floyd's neck. There were 3 others, and they were just standing there, not doing anything, okay? Questioning each other, and a duty to accept responsibility for our actions or inactions. You might recall just the past couple of days, there was a case in Philadelphia, the subway case, where a series of about 5 or 6 bystanders on the subway, at least that many, where a man was raping a woman on the public subway for quite a length of time through several stops in this subway. What were bystanders doing? They were standing there, some of them pulling out their phone and taking pictures rather than calling 911 and rather than intervening. So we don't want to sit back and be bystanders as EMS practitioners when we're working with police and we see someone who needs help. or at least needs an assessment. So, okay, you sure you don't want to do some of this?
I'll jump in.
Come on, let's go through the lessons learned. Come on. All right.
All right, thank you. I make it not a practice to try to interfere with my partner when he's making incredible amounts of sense and speaking so eloquently. But so, Steve talked about implicit biases in decision-making. And I do want to pick up on that because, EMS works closely with law enforcement, and that is good, and that is proper, and the public usually benefits from that. And it is a good working relationship. But it can't be at the expense of recognizing that the medical responders' duty is to a patient, not to law enforcement. We are not, and this case brings into specific relief the notion that our duty is not to help subdue a patient or to take a person into custody or to take them down or control them. Our duty is to the care and well-being of that patient as EMS responders. And sometimes that line is blurred because EMS does straddle the line between public safety and healthcare. But these cases are making it stark that that duty is to be a patient advocate. And one of the critical findings in the investigative report in the Aurora case is that there's a belief, or at least a practice, that the EMS duty doesn't start to the patient till law enforcement says it does. And what Steve's talking about is the duty to intervene in some cases. And this is difficult, folks. And I don't want to give short shrift that, EMS should run in and knock over the people with the badges and the guns. Because that is a difficult, highly charged situation. And a lot of us in this room have been in those situations. But EMS has to properly train and orient itself and its providers to be able to de-escalate and to intervene for the good of the patient. And I think we are going to see the evolution and development of training programs meant to do exactly that. One of the other things that I want to say is that a postscript to the Elijah McClain case is that the state of Colorado enacted legislation now that severely restricts the administration of ketamine. In fact, it prohibits it in cases where law enforcement is present, unless certain criteria are met, specific training, specific equipment. And, that may be fine and well, but the fact is that Steve mentioned that there are other tools that EMS providers have in the drug box that can do the same things or similar things that ketamine does. Ketamine has become the political symbol or the poster of the EMS drug box because of the fact that it has been used improperly at the direction of law enforcement. Bring the bus, give the guy ketamine, make our life easier, subdue him with a drug. Fine, take away or restrict ketamine. There are benzodiazepines, there are paralytics, there are a whole range of drugs in the drug box that can accomplish the same purpose. The issue is not ketamine. The issue is the subordination of medical judgment to law enforcement direction. And that's where the breakdown in the treatment of Elijah McClain and similar cases has happened. And that's the issue that brings this into specific focus, that reaffirms that our duty in EMS needs to be to the patient and to the patient's well-being and patient advocacy. And look, Elijah McClain, the evidence suggests was not doing anything wrong. The evidence shows that in New York, in the Eric Gardner case, that his infraction was relatively a minor one, which escalated. But at the end of the day, it really doesn't matter if the person who is on the other end of that law enforcement interaction is a bad guy or not a bad guy. At the time their airways are compromised, at the time their level of consciousness is impaired, they're patients. And whatever circumstance they were in that got them into that point of being a patient, we take them as we find them. That is a key aspect of the delivery of healthcare and medicine. Not to judge, not to say they had it coming. And folks, I'm not saying that the medics in either of these cases, any of these cases, said that or had ill will or believed that. But what I'm saying is that there's certainly superficial evidence that that might be the case in some of these videos. And these cases reaffirm that there's a misplacement of our duty and a subordination of that duty, which we owe to patients in cases sometimes where law enforcement is involved. The Colorado legislation that restricted the use of ketamine also now politicizes to an extent the administration of healthcare. And we asked for it by conduct like that. Don't expect legislatures to not get involved when we don't uphold that duty. And, you know, we are going, I think, now to see a greater public policy and political examination of what it is that we do. Self-regulation of a profession is always preferable to making it a political issue. And that is why the involvement, the close coordination with folks like Dylan, state EMS officials who understand those issues and how we can better police ourselves and reaffirm that duty is critical. Because if we don't do it, we can expect public policy makers and legislators to get involved, sometimes with good intentions, but not always the best of results.
Right. Doug, if I could just add to that.
Of course, can you unmute? You
I
unmuted
am
there?
unmuted.
Good, thank
but,
you.
You know, I'll just stand up.
Yeah,
here.
sure.
We got masks on, we're okay. To bring it back to the legal points, do we think that this is a case that's going to end up in convictions? Do we think this is an appropriate indictment? No, we think this is prosecutorial overreach, no question. To try to criminalize protocols and call a bona fide medication a deadly weapon, that's going pretty extreme. But that's, as Doug said, this is the kind of thing we're going to see more of. And what is also happening now is there's a move among the states now to abolish qualified immunity for police officers, and that could extend eventually to EMS. We haven't seen that happen yet. If we continue to not learn the lessons from this case and the others and get our house in order. So we're dealing with, potential change of, our legal protections as a result of not having our house in order. So.
Yeah, no, excellent. Thank you. So a couple of other postscripts here that I just want to mention. And that is, Steve has talked about that this case, from a legal standpoint, to bring it back to our CLE and reason for being here, is that there have been criminal cases against EMS practitioners in areas that Steve has talked about. But to criminalize standards of medical practice is really one of the more unique theories in the Elijah McClain indictments. Again, not to issue undue political commentary, but I think it's, from a factual standpoint, it's important to remember that the county prosecutor, the DA, declined to bring charges in the Elijah McClain case. As Steve mentioned, the charges were brought when the state attorney general convened a criminal grand jury. And the attorney general's office also acknowledged in the press conference announcing the indictments that they would have their work cut out for them to get in convictions against the paramedics. It may be easier against law enforcement, particularly in the wake of the George Floyd convictions. But as against EMS, the prosecution knows that that is a novel theory. But I think one of the takeaways of the Elijah McClain indictments is the criminalization of medical standards of care. And that is the aspect of this case legally that is really on uncharted ground here, uncharted territory. And as Steve mentioned, and as Ken mentioned this morning, or somebody did, I'm sorry if I'm misattributing, but when we talk about ordinary negligence, gross negligence, and then intentional misconduct or criminal misconduct, in the past, when there have been deviations from medical standards of care, it is a basis for medical malpractice, civil liability, right? Often covered by insurance. It's been the basis for administrative action. And certainly a state EMS regulatory agency can and should investigate whether the conduct of providers who don't uphold those standards of care is a grounds to limit, suspend, or revoke their licenses or certifications. But to then say that that is the basis for criminal charges, keep in mind here that the basis of the indictments against the paramedics is that you wrongly diagnosed, and by the way, that they do use the word diagnosis in their indictment. And historically, it's always been said, well, EMS doesn't diagnose, that's what physicians do. we've always thought that that's been a little bit, what's the legal word? Poppycock. Because if we don't have a differential diagnosis, then what are we doing providing treatment to a patient? You got to know what the condition is before you can effectively treat it. So I think clearly we do diagnose, but the basis of the criminal liability is that the providers incorrectly diagnosed excited delirium. And that because they incorrectly diagnosed it, they were operating under a protocol that they shouldn't have been operating under. And that by administering ketamine as part of that protocol, you were then unlawfully administering the drug. And I want that to sink in here for a second, folks. My chuckle is no indication of taking this lightly, but it is an indication of how far the prosecution is taking that idea of criminal liability. And I'm not making light of it, but it is such a novel theory that to say that incorrectly diagnosing a condition and then entering the protocol for that condition is not only an error in medical judgment, but a basis for criminal liability. And for that reason, the day that these indictments came out, Steve and I co-wrote one of the longest pieces we've probably published in years on the website ems1.com. And I was worried that nobody would read it because it was so long, but for about 6 weeks, it was the most read and commented article on that site because of, it's just important that our profession understand the novelty of that theory of criminal liability. And that is really the point I want to drive home. That article, by the way, is in the extended handout packet, which was emailed out to attendees. Also in that packet are, when that article ran and became widely circulated, our phones were ringing off the hook to do podcasts and to comment, the Denver Post, USA Today, other publications that we've both been quoted in over the last 6 weeks or 2 months. Some of those articles are in the packet as well. But that we really do want to emphasize sort of the novelty of those theories. Steve, let me hand it back to you. I know you've got some other points you want to make, but I do also want to open up, and I sort of disregarded our death by PowerPoint here, but I do also want to open it up to questions that folks may have, if there's any cards or even live questions, which we'll repeat, because this is such a controversial case. We do want to leave some time for that. But Steve, before I cut that off.
Great
go ahead.
thoughts, great comments for sure. We are learning from this. A lot of medical directors are now reevaluating. Well, what is excited delirium? If you ask 5 paramedics, what is excited delirium, you'll get 5 different answers. And that's being used as an excuse sometimes. So we're learning from that. A lot of medical directors are backing off from that. The other issue is this whole bystander phenomenon, when bystanders remain silent. If we don't sit back, or if we sit back and do nothing when we observe bad behavior, then we're just, sending the message it's okay to do it, And that happens when we have group dynamics operating like we see in the EMS, fire and police services. We do see that. People are sometimes hesitant to speak out against a partner or a colleague because of the ramifications, the problems with concerns about retaliation. And, the other thing is we're all in this together and no one else can really understand the situations we deal with. Well, that doesn't, take away the importance of treating everyone with respect and dignity, as we've already mentioned. So we really got to collaborate with police ahead of time. I think that's another message learned here, to get with them ahead of time before these kinds of incidents occur so that you can develop proper role definition and handoff procedures. Absolutely important. And a lot of agencies are starting to do that. And don't let complacency become complicity. As we saw in the George Floyd case, it's not just one police officer who's going to trial. One has been convicted now of second-degree murder. We have several others now because they didn't do anything, okay? They weren't just complacent, they were complicit in the criminal conduct of that one police officer. And lastly, always remember the reason we're in this business is to help other people. That's why we got into this in the first place. At least that's what why most of us got into it. But first, do no harm, our prime directive. Primum non nocere, did I say that correctly?
I believe you did.
Latin phrase, first do no harm. There's a good place to see it on a tattoo. But we sometimes forget that. And when our conduct actually causes harm, well, then, that's when we really are having.
Sorry, but I do
difficulty.
see redness around that
Yeah,
tattoo.
it
So
wasn't
the
a
tattoo
good-
artist did not follow the directive of first do no harm. But anyway.
Apparently not, apparently not. So, okay, with that, open it up for questions. Now we're really on the schedule.
A couple minutes, but there's certainly other points to be made here. But do folks have comments? And folks, let me remind you, if you're watching on the Zoom feed, and let me get rid of the screen sharing here, so we can bring the camera back.
Good.
To enter those in the Zoom chat, Corinna is monitoring those. If anybody has any cards, wants to submit anything verbally, please feel free to do that, or submit anything in writing. But do folks have thoughts that they'd like to share? I'll be happy to repeat for the audience. Hope we teed up that this is controversial, but does anyone have anything they'd like to share for the good of the order? Mr. Logan.
For probably the last 60 years. And necessarily those scenes were tertiary to police. Do you have any recommendations on how we bridge those gaps so that we could intervene? Because most EMS providers are extremely reluctant to intervene in a law enforcement matter.
I heard Steve inhale behind me, which means he's ready to use that breath for a good
Here it
cause.
comes.
So
It's all about, the culture, and you got to work with the high levels in your government. Oh, I'm sorry. How do you deal with that conflict between police, fire, and EMS when, EMS are concerned about, if they do intervene, what's going to happen to them? Is that the gist of it, John? Thank you, John Logan, for that excellent question. And yeah, it's all about the culture. And unfortunately, the culture in this fire department was, in this report pointed out, was lackadaisical, stand off, let the police run the show. You can't do that. And then you got to get to the high level people in the organizations, the top people, and they got to send the message that we got to work together and change this so that this kind of thing doesn't happen. And then develop and do training, role playing, and things of that sort ahead of time so that you practice. What do we do in EMS all the time? We practice mega codes, right? And all those scenarios where we don't see that many of those. But how often do we see mental health patients and patients in this kind of situation? A lot. Do we do any role playing and mega code stuff with that? No, we need to really up our game in terms of training. So did that answer your question?
yeah, I want to take another tack on that, and I'll go back. Now I'm dating myself as the dinosaur that I am, but I took my EMT basic training in 1981, and yours was probably before that, John. Hate to throw you under the bus, but there's plenty of room where I'm at under that bus. But back in the day, and those folks who have been EMS practitioners, not looking in any particular other dinosaurs in the room or anything like that, but we can remember the time when we were trained to just run in, right? Whatever was going on, access the patient at all costs. And, there were several things that happened, tragic as they were, that recalibrated that notion, where then it became scene safety, that we stage at a safe place until others, whether it's hazardous materials or dangerous or violent person on the scene, neutralizes that threat. Then Columbine happened, and it went back to, you didn't go in, right? So then it became a shift to training with tactical medicine so that medics would be on those teams that would be trained to go in even while there were active threats. Now that back and forth between accessing the patient, then hanging back and staging, and then why didn't you go in and access the patient? And there were lawsuits, by the way, over delays of treatment in the Columbine case. All, I think, demonstrated the responsiveness of and how the industry had to recalibrate its training to meet new and evolving threats. And I think the phrase I keep using is the subordination of medical judgment to law enforcement often comes from the fact that law enforcement is the dominant public safety office present at those scenes. They know how to exercise authority. They're very persuasive in doing that. And and that's not a bad thing either, but it can be used in bad ways. And EMS, the subordination of that in some ways is natural human instinct. You have the badge, you have the gun, I'll hang back till you tell me it's okay. Unless we train for that, like Steve said, and it becomes muscle memory, then I don't think can expect EMS to be able to effectively intervene in those cases. So that's where I would go with that. But yeah, we're running out of time on this panel, but we do have a minute or three for any. Yes, sir.
It was just yesterday or a couple of days ago out in Dallas somewhere. A paramedic, it was on body cam, head kicked a homeless man while a complete engine company and police officers were standing around watching it happen. After the head kick came, then the paramedic proceeded to punch this person, and at no time did law enforcement or anybody else step in to stop it. And I sometimes wonder why we get the reputation in EMS that we get. And I also believe sometimes we're our own worst enemies when it comes to this. So I don't, it's just one of those things, once it's on camera or on social media, it's out there. And when I watched that, it just made me sick that no one, police or the fire, stepped in to stop this gentleman after the first action, they were doing the second action. It was just disgusting.
Okay, let me just quickly repeat it. And Steve, I'll cede the mic. That the gentleman was commenting that just yesterday there was video, I think you said yesterday, video of a case in Texas where paramedics were literally kicking in the head a homeless, I think you said homeless person, while police and fire officials firefighters stood by and watched it happen repeatedly. So that was
Right.
the comment. but you wanna
Exactly.
comment
And
on
what
that?
makes it worse is there was a grass fire that occurred and they got called, and this gentleman had been assaulted before they got there. And they immediately, implicit bias, assumed here's this guy probably started the fire and literally spun around and kicked him. Now, this guy was a trained ninja fighter, okay? He's a professional fighter in the ring. He does all these things. This guy, now there's talking about deadly weapons, that there's case law where your ability to do that sort of thing can be a deadly weapon. So it'll be interesting to see how that pans out. But the department initially didn't see any wrongdoing at all. And that goes to your point, we protect our own sometimes too much and don't call out the bad apples. And when we don't call them out, then other people think that behavior is okay, and this guy, and then he went and challenged him like this, did that maneuver, bad situation. And the one good thing about body cameras we're seeing, there's a lot of good things about them, is some of this stuff is coming out. We're seeing more transparency and accountability, and that's going to change behavior.
Okay, well, thank you folks for the great comments and input on that case. And we appreciate your tolerating our schedule change to address that topic just because of its timeliness and importance. Okay, with that, I'm now going to reintroduce our keynote speaker for today's program, Ryan Stark, Esquire, a graduate of Widener Commonwealth Law School, began immediately after graduation as an associate at Page, Wolfberg & Wirth, was later named a partner at Page, Wolfberg & Wirth, along with his colleague, Dan Pedersen. And I want to emphasize just for 1 second how impressive it was to be named a partner at Page, Wolfberg & Wirth, because until then, we had no partners other than Page, Wolfberg & Wirth. So the fact that we got Ryan and Dan to join us and have been such indispensable parts of our practice for all of these years is our good fortune and the good fortune of our clients who have benefited from their wisdom and expertise. So Ryan is going to talk about 8 essential habits of poised leaders. And it's my pleasure to introduce our keynote speaker, Ryan Stark.
Thank you. Bring up the slides here in just a moment. Okay. Thank you. Yeah. He said if I go on too long, he's just going to come up and tackle me. That's what he just said.
Let the record reflect I did not say.
All right. Thank you very much. So we've officially transitioned from our regular program into the ethics portion of the program, right? That's kind of like the corollary here. 8 essential habits of poised leaders. I wanted to talk about this because we are amidst a pandemic and a really trying time in EMS and throughout our nation right now. And we so need poised leaders throughout this pandemic and ongoing throughout this. So I distilled what I thought were the 8 essential habits of poised leaders. And I'll be brief. I know I'm the only person standing between you and lunch. This has been a great morning of content, but let's just go through. Number 1, they say yes and they fail daringly, okay? Not succeed daringly, but fail daringly. Anybody can succeed, but to fail daringly, to put yourself out there, to be vulnerable, takes a lot more. Michael Jordan once said, I've missed 9,000 shots. I've been entrusted to take the winning shot of the basketball game 26 times and missed. And the reason that I succeed is because I fail. We desperately need leaders that say yes and who fail daringly right now. Who are those political advocates on the Hill who year after year advocate for things like direct pay legislation, who take on initiatives like mobile integrated healthcare, community paramedicine, and who conduct outreach. I remember in law school, I was on moot court, and one of the things we didn't have an international law moot court team here at Widener University, right? Believe it or not, here in Harrisburg, Pennsylvania, we did not have an international moot court team. So we decided to form one of our own. It was Jen Hiskey, Dave Sunday, who is now the district attorney for York County, Pennsylvania. And we took a trip up to New York City because David worked for the United Nations. And we read every treaty we could get our hands on. We had professors mooting us who knew nothing about international law. And we got Professor Dernbach to take that trip up with us. And I'm happy to say today that we went up there and we got our butts kicked, okay? We failed. All the preparation in the world, but we learned very valuable lessons as a result of that trip. We went back and did it again. It's those who are willing to put themselves out there who deserve the credit. And I love this quote by Theodore Roosevelt. One of the things that we have to remember is it's not the critic who counts. It's not the man who points out how the strong man stumbles or where the doer of deeds could have done them better. The credit belongs to the man who's actually in the arena, whose face is marred by dust and sweat, who strives valiantly, who errs but comes up short again and again. Great devotion, spends himself, who at best knows in the end the triumph, the great achievement, and who at worst knows if he fails, at least he fails while daring greatly, so that his place shall never be with the cold souls who neither know victory nor defeat. Stop holding space for the critics in your life. It's the man in the arena who counts. It's not the critic who counts. Along with that, great leaders practice self-compassion. They realize that they do fail. I want you to think back to one of those moments where you walked away. We are our own worst critics, ladies and gentlemen. I am definitely my own worst critic, and we beat ourselves up like crazy. We cannot have empathy and be compassionate for others until we're able to have that self-compassion. One of the things I want you to do is think about what a colleague would say to you in that circumstance if you conveyed those same circumstances to them and they said, this is what happened. What would they have said to you in that moment? That's what our self-talk as leaders needs to be. You're doing the best you can. Brene Brown is one of my favorite authors, and she's a researcher. And one of the things she says is when they go out and conduct research, they ask folks this question: do you believe others are doing the best they can with the tools that they have? And she said, I get a pretty even split. About half the people say, hell no, that can't be true. Or the other side says, apologetically, yeah, I think that is probably the case. She said the most profound response that I got to that question was when I asked my husband, and he said, let me think about that. And he said, you know, I don't know if everybody's doing the best that they can with the tools that they have. But when I believe that about others, my life is a lot easier. Great leaders, poised leaders, tweak advice to suit them. They know when edicts come in, when advice comes in, what fits their organization, what fits their people. So I was talking to one of my friends recently, you know, and I'm always looking for ways to get ahead, to lose a few pounds. And I have my whole life, right? You know, and people give you advice. And somebody told me, one of my friends told me recently, because he had lost a lot of weight. And I was like, how did you do it? So I'll tell you exactly what you have to do. Intermittent fasting, okay? I know you've heard of this fancy term. Like, tell me more. Just, well, I don't eat until 5 p.m. every day, right? I'm like, oh, you just don't eat all day. Like, sounds like a great idea. That is not a good idea for me, okay? Because at the end of the day, I'm not going to eat all day, and then I'm going to consume about 4,000 calories after 6 o'clock when I order the Domino's pizza. Point being, we tweak advice to fit us, to fit our people. Poised leaders invest in people who invest in them. Many times we're told that we need to be, you know, aligned with this person. You know, oh, we're friends with so-and-so. Think about the people in your life who really invest in you, the people in your organization who will give it to you straight. Those are the people who we really need to invest in. Our family members and the folks who we've trusted throughout that. You know, here's the reality. We need to make sure before we bring people on that they're willing to invest in us. And when I talk to really good organizations, part of their onboarding process is getting buy-in for the philosophy of what they do. They do things like we do the right thing. We expect more than good clinical skills. We expect good documentation. We expect caring, compassion. We expect that you're going to take care of the folks that we treat. Invest in those who invest in you. Speaking of, I got to call my mom after this presentation, right? She's one who invests in me. And I haven't called her in a little while. And I texted her this morning. She said, how you doing? I said, I'm going to do a keynote at my old law school today. And she said, why don't you call me and let me know how it goes, right? I got to invest in her. That's renewing to me. Poised leaders cultivate and endorse within themselves and with others within their agencies, rest and play. I've never churned out a good product at 3 a.m. after exhausting myself and trying to think. Rest is so critically important where we're in our lives right now. The other corollary to that is play. We need to allow ourselves to do what it is to let go. Think about times that you're able to be in the moment, whether it's running, biking, being creative. You know, I was reading Brene Brown's book, and she said a lot of people get away from the creativity part of their lives because of a scar. They've always been told that they're not creative. I can't sing worth a lick. I admire Doug Wolfberg for getting up on stage and you know, putting himself out there. He's a much better musician than I'll ever be. But I can engage in other creative endeavors. And, you know, my son and I have taken up a little bit of canvas painting lately. And when I'm in that moment, when you're exercising that part of your brain, you can let go. We need to cultivate that within ourselves and within our organizations for our people. We support avocations. We support alternative work schedules. We cultivate rest and play. The opposite of play is not work. The opposite of play is depression. One of the other things that I've realized about poised leaders is they believe that they are worthy today. They don't go into work saying, if only I could achieve this title, I'll be significant for my coworkers. If only we'd gotten that grant, we could move forward within our organization. They believe they're worthy today. I am enough today. You know, I know I've made it. I have made it when. Good leaders realize their station and they can lead from that position. If you're leading from a position of scarcity, saying, I need to achieve this, you're not going to be in a position of poised leadership. Good leaders give gold stars and they stop getting as many gold stars. Right? Good leaders start giving gold stars to their folks. They look at opportunities that come in that they're given and they pass those opportunities along. Poised leaders also celebrate the victories. We have to, from time to time, take stock at where we're at and say, nice job. If we're measuring metrics and setting goals, we have to recognize when we achieve those goals and take a minute and stop and pause for a second. How hard is that to do within our industry where we're constantly at the beck and call of, that 911 dispatch? We need to stop and celebrate our victories. And after that great call, turn to one another and say, heck of a job on that. One of the things that I've realized too, and we're guilty of this, everybody's guilty of this, is we're guilty of foreboding joy. What do I mean? Putting it off. So we have the picture here of these two providers. Let me paint the scene for you. These two providers just came back from a save. They just worked the patient. Amazing job. They got him to the hospital. The hospital just called them. Said, excellent work out there. And then I ask people, we're in part of a movie right now. The camera pans out. What happens next? Matt's over here thinking, 911 tones come off and everything goes to chaos, right? Stop foreboding joy, and in those moments, take time to recognize those milestones. How do we do that? You practice gratitude. I hear a lot about you need to have an attitude of gratitude. The only way to do that is to practice gratitude. It's about saying thank you. It's about making a list of what we're thankful for. It's about in that moment when I'm laying with my son and he says, I want you to snuggle with me. This happened last night. And I'm walking out and I'm watch him sleep. I take 10 seconds to watch him breathe. I say, thank you, God, for what I have. That's practicing gratitude. I was at an agency recently near Houston, Texas, visiting them, assessing them for compliance. And I often talk about this culture of compliance, and they say, how do you know the agency's compliant? And I say, I know it when I see it. One of the things that the CEO was doing while I was talking to the compliance officer over lunch, he said, excuse me, but I'm going to write out happy birthday cards. He handwrites birthday cards, and this agency had about 1,000 employees. He said, I handwrite birthday cards to all of our employees. And I'd be sure to mention something about them, an accolade in that card. That's practicing gratitude. And I'll leave you with this. This is not my quote. This is actually the brother of Jeff Bezos, Mark Bezos. He happens to be a volunteer firefighter. And he said, I run my own business, so it's very rare that I get toned out first on calls and, get to show up and actually get to try to extinguish the fire, do anything of meaning. And he said, I've always wanted to do that. That is going to be the pinnacle of me as a volunteer firefighter. And he said, I got so close once. I showed up, on scene. I thought I was going to be first there and I wasn't. There were 3 other volunteers. And he said, Chief turns to the first guy. He says, John, that woman's cat is still inside. It's safe to go to that portion of the house. Fire's almost out. Can you go get her cat? And he's thinking to himself, oh my gosh, he gets to go in and rescue the cat, right? And then he turns to me and he says, Bezos, I need you to go in there and get this woman a pair of shoes, right? Because she's standing there in her bare feet. It's the middle of the night and it's raining. And he says, okay. He goes in and gets a pair of running shoes. And, you know, he's really upset that he missed out on his shining moment. And he said a couple of weeks later, we got a letter from the homeowner. And it said, I really want to thank your fire department and your gentleman for responding to my home. Single act of kindness that I remember most above all was that amidst everything, amidst all the chaos, somebody had it within their heart to go get me a pair of shoes so I didn't have to stand there barefoot for the rest of the night. Not every day gives us a chance to save a life, but every day gives us a chance to affect one, no matter what profession you're in. And we need to remind our folks, especially in EMS, of that fact. Thank you very much.
Outstanding.
Thanks.
So Ryan, thank you for that really inspirational keynote. That was outstanding. Enjoyed that. So with some just final concluding thoughts here, I'm going to turn it back to Dean Hussey. Again, I want to thank Corinna Wilson, Professor Christian Johnson, the Law and Government Institute, Pennsylvania Fire and Emergency Service Institute, the Ambulance Association of Pennsylvania for their sponsorship, support, and participation. Dylan Ferguson from the Department of Health, and all of the attorneys at PWW who have lent their expertise to the program. Most of all, I want to thank Widener University Commonwealth Law School, not only for hosting this for the 3rd consecutive year, but for their commitment to first responders, emergency medical services, veterans, and others who serve. So I really do want to thank Dean Hussey and everyone here at Commonwealth Law School who have made this event happen. So with that, Dean Hussey, it's all yours for concluding remarks.
Thank you, Doug. I'd like to thank again everyone responsible for putting this program on today, and I'll add my thanks to Doug's as he thanked all of the individuals responsible for this. It's great to be back doing CLEs again on campus, and those of that has joined us online as well. Thank you for that as well. And we're proud to host this. We're proud of being able to do the work that we do with first responders and the Veterans Initiative as well. So this is just a wonderful opportunity to get together, to learn today, and to celebrate that work. And so thank you again to all of you. Have a good day, and we see you next year.
I certainly hope.
We'll see you next year.